So, hello, ಕೋರ್ಟ್ ಆಗಿಲ್ವಾ? ಕೋರ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ.
Order.
Adjournments ಇದೆ ಕೇಳಿ.
Any adjournments?
Serial number 12, my last.
12.
Seek a week's accommodation. Serial number 12.
1 sec.
12.
Page wise ಕರೆದ್ಬಿಡಿ adjournments. First page ಇಂದಾನೆ ಕರೆದ್ಬಿಡಿ.
Page 1.
Serial number 21.
Page 1.
One page wise ರೀ.
1 to 4. 5.
Serial number 1. ಏನಾಗಬೇಕು?
Applying for the respondent number 2.
1.
Pray for a short accommodation, your lordship. Senior counsel will appear in this matter.
Petitioner this matter.
ಆಯ್ತು.
This matter pertains to whether a 482 order can be recalled, your lordship.
See, what is this Ray?
Short
You
accommodation.
almost finished. You see, at your sake, dates were fixed and I can't release it also. I only have to do it because I have delivered the judgment.
So the senior
Policy.
advocate made the submission that he has completed his argument. They also said, and the matter was adjourned only because the government.
I don't know when I will be sitting single once again.
You know, that more than 12 hearing dates, same
Apologies,
thing
your
is
lordship.
repeated.
Senior wants to make some more submissions with respect to the judgments, your lordship.
The
Small-
matter was adjourned only because the government advocate submitted that it was to file the memo stating that the original will is not available.
I call after 2 weeks. Next ಯಾವಾಗ sitting ಆಗುತ್ತೆ single ಅವಾಗ ಹಾಕೊಂತೀನಿ ಅವ್ರು ಮುಗಿಸ್ಬೇಕು.
Please, your lordship.
At the request of respondent number 2, call after 2 weeks. Yes.
Much obliged.
See number 5, 6 to 10, 11 to 16.
Serial number 4. Serial number 6.
Week's accommodation. Okay for respondent number 1. Respondent number 1.
2 weeks.
Serial number 15, my lords. Serial number 15.
You are for 2 weeks.
Serial number 16,
Serial number-
sir. 16, sir, my serial number. 2 weeks time, sir. Senior.
16
16, sir.
16 2 weeks. You are
Serial
for
number.
number 12.
ಯಾರಿಗ್ರಿ?
Respondent, sir.
ಆಯ್ತು.
Serial number 12.
ಹಾ.
Petitioner.
Serial number
Aye,
4.
two
Serial number 14, my lord. Appear, pray for 2 weeks time, my lord. Appearing for the petitioner. The interim order may be extended.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ನೋಡ್ಬಿಟ್ಟು.
See number 17 to 23.
My lords, serial number 20.
ಹಾ?
20. 20, sir.
20.
ನೀವ್ ಯಾರಿಗ್ರಿ?
And for the petitioner,
2 weeks.
IA ಇದೆ, sir. Interior matter ಇದೆ. maybe.
ಹಾ, ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ನೋಡ್ಬಿಟ್ಟು.
21 to 23.
Serial number
Adjournments.
25,
ಹಾ?
serial number 25. Lordships had called for record.
ಅಲ್ಲ 21 to 23 ಇದು ಆಯ್ತು.
24 to 27. 25.
25.
The parted matters.
ಏನ್ ನಿಮ್ಗೆ ಯಾವ matter ಇದು?
Lordship had directed the lease deed to be produced through the government. I don't know whether they have. Deed of,
ಅವ್ರು ಮಾಡಲ್ರಿ ಅವ್ರು.
ಅವ್ರು ಯಾವ
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಅವ್ರು ಮಾಡಲ್ಲ ಅವರು.
ಆಯ್ತು. ಅದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್
They have not even requested the KDB to produce it.
I thought the request of petitioner call after 2 weeks, release from parted, sir.
But let it be there, my lord, we will take the chance. Whenever.
Sir,
the
it may
lordship
not,
sits
it may
single-
not look nice, sir, because see, I'm sitting in the division bench for 2 months at least. I don't know when I will be able to sit single. That's the only reason, sir. Just release from parted, call after 2
Let
weeks.
your lordship have given me the protection, let the protection continue.
ಏನ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ?
Protection that I should not be interfered, my possession should not be interfered with.
ನಿಮ್ ಪರವಾಗಿ ಆರ್ಡರ್ ಆಗಿದ್ಯಾ?
ಹೌದೌದು.
ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್.
ಕಿತ್ತೋಳೆ. ಕಿತ್ತೋಳೆ ಯಾರು? ಕಿತ್ತೋಳೆ.
25 ತಗೊಳ್ಳಿ, ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ.
ಆರ್ಡರ್ ಶೀಟ್.
ಏನಾದ್ರು ಮಾಡಿ.
25. ತರಿಸ್ತಿದ್ರೆ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಕೊಡಿ ಅದು. Sir, it's absolute ಅಲ್ಲ.
No time limit of course.
No further orders are required.
Further,
ಅದೇ.
But madam, my only submission is your lordship is for some time.
Correct, sir. The petitioner does not want to go about with the matter, number one. Number two, I don't know when I am sitting single, sir. That's the only reason. It may not look proper.
We appreciate that.
See, if I were to, I thought I'll be in Kalburgi and I told everybody in all these matters who were insisted that, okay, I'll go to Kalburgi, I'll appear by video conference. In fact, that's what I told. But there was last minute reshuffling and I am sitting in Kotal number 1 now.
I know.
So, question of,
I know.
I don't want to keep this burden on me. ಯಾಕಂದ್ರೆ 2 months ಏನೋ ಆಗಲ್ಲ, ಸುಮ್ಮನೆ ಯಾಕಿದ್ದದ್ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟ. Yes.
27,
Release from party.
28, 29.
28, my lord. I am
Ah.
sorry, I am not keeping well. I would have.
The request of petitioner call out for 2 weeks, release from party.
Interim order may be extended, my lord. It is already there.
Order ಏನಿದೆ ಅದನ್ನ extend ಮಾಡಿ ಅಷ್ಟೇ. ಅದೇ interim order extend ಮಾಡಿದ್ದೀನಿ.
Time ತಗೊಂಡಿದ್ದಾರೆ. Interim order may not be continued.
Sir, it's a one-off sitting, sir. I'm releasing it from parted
Yes.
also.
Yes.
Yes, post it before, ಎಲ್ಲಾನು post it before appropriate bench ಅಂತ ಮಾಡಿ. Previous one, ಇದನ್ನು ಅಷ್ಟೇ.
I'm sorry, I could not do it.
Yes, sir, no problems.
29, 30, up to 35 any adjournments.
35.
ಹಾ.
34, my lord, I'll file objections, my lord, your lordship, I've already heard this matter.
You want time,
I'll file objection, one statement.
My lord, we want to make submissions in this matter. My lords may
The-
kindly not, my lord may kindly hear us today.
No, they want time. Question of hearing does not arise.
My lords
They
may
want
kindly
to complete the pleadings. They want to file their objections. What to do?
regularly matter ಬರ್ಲಿ submission ಮಾಡ್ತೀವಿ my lords.
Correct, sir, but respondent state wants to file their objections.
The short submission, my lords, is that there is urgency in this matter for.
Correct, I've heard it also. I thought it will be completed, but respondent state wants to file objections. What can I do? At the request of respondent number 1 and 2, call after 2 weeks, post the matter before appropriate, release from parted, post the matter from before appropriate bench.
35.
35 ಏನು? ಇದು parted ಇದು?
Yes, sir.
Please,
Okay, ಇದು same order. At the request of respondent,
let it not be released, my lord. Senior has stopped. Extensive arguments have been placed. They have filed the statement of objections also, my lord. Feeling is complete.
see, they want time, I can't help it, sir. At the request of respondent, call after 2 weeks, release from parted, post the matter before appropriate bench. See, if I were to sit single, I would have continued. Because I am sitting in division bench.
What the matter, your lordship, have heard extensively. Only in the 35.
Correct.
I want to place only one thing, my lord. Against the division bench order, my lord, we filed and review petition.
Leave it, do what you want.
Filed, my lord, that I want to.
Go before the appropriate bench, that's all.
Your lordship.
Sir,
Serial number 2, Rakshita DJ. Serial number 2, Murugesh with Charati.
ಏನ್ರಿ ಎಲ್ಲ ಬಿಡಿ ಇದು ಪಾಟೆಡಾ?
Yes, sir. Pattern.
Dispose ಆಗಿತ್ತು.
Oh, disposed, ah?
Survey report ಹಾಕಿದೀವಿ, survey report is to be placed.
ಏನಿದು
before you.
ಈಗ? ಅಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲಿ ಏನಿದು? ವೈ ಇಟ್ಸ್ ಪೋಸ್ಟೆಡ್?
Disposal ಅಲ್ಲಿ your lordship that directed us to file a
Complaints report.
ನಾನು ಆಮೇಲೆ had sought for extension of time for survey. That was allowed by your lordships.
So mention.
Then not survey report is filed. But from here not will have. Lordships had fixed a date for survey. After that I had sought for extension. ಅದಾಗಿದೆ, ಸರ್ವೆ ಆಗಿದೆ, ರಿಪೋರ್ಟ್.
Once submission, my
Then
lord.
why is it posted?
We gave her the NOC, my lord. The party has taken the file. So
No, that's okay, sir. What further needs to be done? One survey is given.
Properly conduct the survey, they are not.
That you challenge it, sir.
Day after tomorrow. Today.
The writ petition was disposed of with the direction to the BDA to conduct the necessary survey and gave a copy of the same to the petitioner. Full stop. The counsel for the petitioner, the counsel for respondent BDA submits pursuant to the orders of this court, survey has been conducted. In the light of the same, no further orders are deemed necessary in the instant, no further orders are required to be passed. It is needless to state, if the petitioner is aggrieved by the survey conducted by the respondent, he is at liberty to challenge the same in the manner known to law.
My name is, I'm filling NOC.
ಏನ್ ಮಾಡ್ತೀರಾ ಮಾಡಿ sir? Yes.
ವಿ ವಿ ಗುಂಜಾಲ್.
I don't know why it, one second, wait, first, why it was posted?
That was complaint.
No, why office na ಕರ್ಸಿ ಇದು? ಇದು ಆರ್ಡರ್ ಬರ್ದಿಟ್ಕೊಳ್ಳಿ. I don't know who has got it posted, why it is posted.
It was that the instance of BD application was filed, then your lordship had directed, let's see what happens on that day, you come on that day, your lordship had indicated, that's why it is posted.
So there was a specific direction. to-
No, last time ಆರ್ಡರ್ ಏನಾಗಿದೆ ನೋಡಿ. ರೀ ವಸಂತ್ ಕುಮಾರ್ ಅವರ ಒಂದ್ ನಿಮಿಷ ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡೆ.
ಆಯ್ತು.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ? You they had asked for extension of time. That filed an application.
ಏನಾಗಿತ್ತು ಅಂತ ಕೇಳ್ತಾರೆ.
ಆಯ್ತು. ಇರ್ಲಿ. Yes, that's it.
ಶ್ರೀ ವಿ ವಿ ಗುಂಜಾಲ್.
ಇದು ಎಲ್ಲ KDB ಯಾವ್ದಕ್ ಬಂದಿದೆ ಇಲ್ಲಿ?
This
ನನ್ನ
matter,
ಹತ್ರ.
my lord,
ಪಾಟರ್ಸ್.
no doubt, the matters
Parted.
have been heard by the division bench. But the distinction is these, in this case, the admit.
Sir, I am releasing it from parted, sir. Yes.
May I make one request, my lord? They have initiated.
ಅಲ್ಲ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ನಮ್ಮ ಮುಂದೆನೆ ಬರ್ಬೇಕಾಯ್ತು.
70 of 2003.
One second, wait. ಇದು ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಬೆಂಚ್ ಮುಂದೆ ಹೋಗ್ಬೇಕಾ ನಮ್ಮ ಮುಂದೆ ಬರ್ಬೇಕಾ? ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಬೆಂಚ್ ಅಲ್ಲ? Yes.
Para 42 of.
ಇರ್ಲಿ ಬಿಡಿ ಸರ್. Release from parted, post the matter before
Let
appropriate.
the LIC not be precipitated, my lord. LIC ಒಂದು ಹಾಕಿದಾರೋ.
Sir, you move it, I'll give a date if you want. At the request of petitioner, call next week, post the matter, at the request of petitioner, call next week, release from parted ಅಂತ ಮಾಡಿ first. ಮತ್ತೆ ಯಾವ್ದಕ್ ಬಂತು?
Last previous, honorable days were disabled and that is the distance for lordship.
ಅಲ್ಲ ಈಗ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ನನ್ ಮುಂದೆನೆ ಬರ್ಬೇಕಾ?
It's on special orders before this court.
No. Just find out from the registry. ಅಲ್ಲ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆದ್ರೆ ನಮ್ ಮುಂದೆನೆ ಬರ್ಬೇಕಾಗುತ್ತೋ ಅಥವಾ can we say? ಕೇಳಿ ನೋಡಿ ಅಪ್ಪ. If we can pass an order like that, we'll pass an order and wash off our hands. I'll pass it over.
Issue is resolved by division bench.
Correct, Chandrasekhar, listen. If, because there is a special order, ನಾನೇ ಕೇಳಬೇಕು ಅಂದ್ರೆ I will adjourn it. ನಾನೇ next ಯಾವಾಗ ಸಿಂಗಲ್ ಕೂತ್ಕೊಂತೀನಿ ಅವಾಗ ಕೇಳ್ತೀನಿ. If I can order that the matter has to go before the roster bench ಅಂತ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ನಾನು ಮಾಡ್ಬಿಡ್ತೀನಿ ಆತರ. ನನ್ಗೆ ಯಾಕೆ ಬೇಕು ಡೇಕ್? So you do one thing, you call the registry and ask them so that there will be an element of clarification.
They are telling special orders, so special, that special order is not necessary.
Number 4.
Okay, go for regular bench.
Election petition.
This I cannot disown. This
Yes.
is, this I have to continue with myself.
One
Even arguments ಹೇಳೋದಾದ್ರೆ ಏನ್ ಮಾಡಿದಿರ ಈಗ?
Nandu 7-11 application I had filed there, in EP3, he has filed application for amendment.
ರೆಡಿ ಇದೀರಾ?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್
file
ಟು
objection.
IF for dismissal of the suit ಹಾಕ್ಬೇಕು. ಅದಕ್ಕೆ
Memo ಹಾಕಿದ್ರೆ I already
I pray for a
filed
week's time, my lord.
What is this? How much time we have granted you counsel?
ಅಲ್ಲ ಲಾಸ್ಟ್ ರೆಡಿ ಇದೆ ಒಂದು
At the
signature.
request of petitioner, finally call on. On Friday ಕೊಡ್ರಿ date ನೋಡೋಣ, let us see. Court officer. On Friday ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಾ?
Friday.
ಒಂದ್ 2-3 ವಾರ ಬಿಟ್ಟು ಕೊಡಿ, ನೋಡ್ಬಿಟ್ಟು. ಅಂದ್ರೆ ಈ ಸಾಟರ್ಡೆ ಸಿಟ್ಟಿಂಗ್ ಇರೋದು ಬೇಡ. 7ನೇ ತಾರೀಕು ಆಗೋಣ. ಫೆಬ್ರವರಿ 7. 25th sitting ಇದೆ, first sitting ಇದೆ. February 7th I will post it. At the request of petitioners, finally call on February 7th.
Only in 7/2024, my lord.
ಇನ್ನೊಂದು?
3 ನಲ್ಲಿ ಇದೆ.
I'm appealing for
ಇನ್ನೊಂದು?
3 ನಲ್ಲಿ ನಾನು 3/24 ನಲ್ಲಿ. So in this matter, my lord, I have to file objections to their rejection of.
ಎರಡನ್ನೂ ಹೋಗ್ಲಿ, 7th ಬರ್ಲಿ ಅಷ್ಟೇ.
Yes.
ಯಾರನ್ನ ಕೇಳಿದ್ರೆ? ಇದು ಎಸ್ ಗುಂಜಾಳ್ರದಲ್ಲಿ
3. BV Gunjal, sir.
Registry, call next week. Registry is directed to post the matter before the bench having the roster. After obtaining the necessary orders from ಆ ರೀತಿ ಮಾಡ್ಬೇಕಾ? After obtaining the necessary orders.
RP 5. Sumana Naganan. Petitioners
in this matter. Respondent in this case.
ಇದು electricity.
But the only question is whether Article 82 or 113 of the Limitation Act is applicable. Their contention is that, my lord, if the death has caused due to the electrocution, it could be under Fatal Accidents Act, for which the limitation.
ಈಗ ಇದರಲ್ಲಿ ಪ್ರತಿಯೊಂದು ಅಕ್ಷರನೂ ಓದಬೇಕು. ಇಲ್ಲದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಿಟ್ಟು ಇವ್ರು ಹೇಳಿದ ಮಾತು ಕೇಳ್ಕೊಂಡು ನಾವು ಜಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಇನ್ನೊಂದು ದೂರ ಹೇಳ್ತಾರ, ಇಲ್ಲಿ ಈ ಅಕ್ಷರ ಬರ್ದಿದೀವಿ ಅದನ್ನ ನೋಡಿಲ್ಲ, ಮತ್ತೆ ರಿವ್ಯೂ ಅಂತಾರ. Based on your submissions, the judgment was passed. And shamelessly you go to Supreme Court and say that this aspect is not considered. When you don't argue the matter. See, we believe the advocates. ಅರ್ಥ ಆಯ್ತೇನಾ? ನಾವು ಪ್ರತಿಯೊಂದು ಪೇಜು ಪ್ರತಿಯೊಂದು ಅಕ್ಷರನೂ ಇದ್ರಲ್ಲಿ ಓದ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ದಿನಕ್ಕೆ 5 ಕೇಸ್ ಹ್ಯಾಂಡಲ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
We were not on record when the RFA was.
No. Whatever it is, see, we are put to embarrassment. ಒಂದು 50 ಪೇಜ್ ಪಿಟಿಷನ್ ಹಾಕ್ತೀರಾ, ಅದರಲ್ಲಿ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಸೇರ್ಸಿರ್ತೀರಾ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಅದನ್ನ ಹೇಳಲ್ಲ ನೀವು. ನೀವು ಮಾಡಿ ಸಬ್ಮಿಷನ್ಸ್ ಮೇಲೆ ನಾವಿಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಬರಿತೀವಿ. ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ನೋಡಿ ಜಡ್ಜ್ ತಲೆ ಇಲ್ಲ ಅವನಿಗೆ, ಅವನು ಅದನ್ನ ನೋಡಿಲ್ಲ, ಹುಚ್ಚುಚ್ಚಾಗಿ ಬರ್ದಿಯಾನೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಯು ಮೇಕ್ ಎ shameless comment. And that's how it has been. The Supreme Court has added, okay, reserved you the liberty to have the matter reviewed. ಹೇಳಿ arguments. ಅದೇನ್ ಹೇಳ್ತೀರಾ ಹೇಳಿ.
My lord, in this matter, I had produced regarding the contention that has been raised now by respondent number 1.
Ready ಇದ್ರೇನ್ರೆ?
Ready.
Both of you are ready, no? One ನಿಮಿಷ wait. Let me go through the things at least first. ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಎಲ್ಲಿದೆ? ಅಲ್ಲ ಇದು SLP ಎಲ್ಲಿದೆ?
The order of the Honorable Supreme Court is at page 85.
How do you overcome Article 82 of Limitation Act?
Please, clearly covered by the honorable decision of this honorable court, my lord, division bench of the honorable court, my lord. Because, my lord, in order to fall within the ambit of Article 82 of the Limitation Act, my lord, the suit should have been filed, my lord, by invoking the provisions of Fatal Accidents Act. So it is the case where, my lord, a suit is filed under the regular provisions of CPC, my lord, for tortious act on the part of the respondent, petitioner herein. So therefore, my lord, Article 113 is applicable. By referring, my lord, the honorable Supreme Court judgment also, the division, honorable division bench, my lord, has clearly held that, my lord, that, my lord, the Article 113 is applicable, my lord, where the limitation is 3 years.
Plaint ಇದೆಯಾ?
Judgment.
Plaint copy ಇದೆಯಾ?
Yes, my lord, it's my lord, the plaint is produced.
Fatal Accidents Act today.
Plaint is at page 34. my lord.
Indian Fatal Accidents Act. ಎಲ್ಲಿದೆ plaint?
Page 34.
34 of the review petition.
It's a very short act consisting of 4 sections, my lord.
Yeah.
Page number 9 is the division bench, honorable division bench solved, my lord. That is at page 9 in the compilation.
Yes, the second ground is owner of the agricultural field has not been made a party to the proceeding.
It is not a necessary party, my lord. The allegation is against the, my lord, the respondent state, my lord, which is the statutory authority. So therefore, my lord, no relief was sought against the owner of the property, my lord. And no negligence is also attributed against the, my lord, the owner of the property. So therefore, my lord, he is not a necessary party, is my lord.
Have you gone through this judgment?
No, it was served to me just now.
Right, the arguments ಹೇಳಿ. No, I won't give you time. Tell
May
the
I
arguments.
request for a passover.
You can, okay, I'll give you a pass over. Half an hour, that's it. Pass over.
Six, Lakshmi Menon.
The petitioner. Let's say tax matter. SVLDR scheme ಕೆಳಗಡೆ this court had allowed my petition and allowed me time to
ಮಾತಾಡ?
make.
ಅಲ್ಲ ಪಾಠ ಆಗಿಲ್ಲ ಇದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ನಾನು
They were
extension-
given, my lord, an opportunity to make a payment even after the due date was over. Now they could not make a payment. So they have sought an extension of time to make payment.
ನೀವು ಕೊಡ್ಬೋದು ಅಂದ್ರೆ ಕೊಡ್ತೀನಿ, ಇಲ್ಲದ್ರೆ ಕೊಡಲ್ಲ.
This is, my lord, the second application.
No, if you consider, I will give, otherwise I won't give.
Last may have next week, my lord. I'll just ascertain from the department whether any order has been passed or not. Let them confirm.
Order
I
has
think.
not been passed.
My
my lord.
department says that order has not been passed, because if they don't pay it under the SVLDRs, the normal, my lord, proceedings, my lord, they go on with
Yes,
by issuing a show cause notice.
the request of parties call after 2 weeks. Call next week ಅಂತ ಮಾಡಿ. Call next week ಅಂತ ಮಾಡಿ, ಯಾವಾಗ next sitting ಆಗುತ್ತೆ ಅವಾಗ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ.
7, Mithun GA.
So this application, Niralgi, this application has to come before me only.
ಮುಂದಾನೆ ಬರೋ.
This is a matter where your lordship directed the tenant who's received a certain package from Metro to return the amount which was given by the Metro authorities. Your lords. In this, it's been more than 6 months. They have not paid the money back to the Metro, and Metro has not paid. the money
Private
to us.
response is preferred in appeal, my lord.
You have to, it's your responsibility to recover from him.
Lord,
That's all.
they have filed appeal, my lord. It's pending.
Been pending since 5 months
You
down.
go there, I can't help it. You have to pay them, that's all.
Since there was no.
You have paid it to the wrong person. You pay it to the right person. You recover from them. Or contact, or get an order against this order before the division bench.
Lord,
If a timeline is
No.
fixed, I can at least move. Lords. Since it says at the earliest, they have not been.
I'll say it next week, do what you want.
please.
The
Grateful.
request of respondents, call next week.
Grateful.
8, Lani Sebastian.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ, they will not serve.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್
Petition withdraw
ಇದೇನು ಪಾಟೆಡ್ ಆಯ್ತಾ?
ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ, ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಹಾ,
ಆಮೇಲೆ ಐಎ ಹಾಕಿದ್ದಾರೆ, ಏನು ಡೈರೆಕ್ಷನ್.
ಏನ್ ಕೈ ಹಾಕಿದವ್ರು ತೋರ್ಸು. None appears for the petitioner, call next week, let us see, let them come.
9, Harish HV.
The client has taken back the file. So please granting 2 weeks time so that we can file NOC and necessary documents.
Harish, he,
Party has taken inverse elections. I'll file necessary memo. There is a.
okay, the request of petitioner, call after 2 weeks.
10,
GMCPC matter, no?
Siddharth Suman.
Appearing to the petitioner, my lords, in this matter, there's a compromise happening between the parties.
The request of petitioner, call after 2 weeks.
11, Ajit.
11, 12 adjourn.
11,
11 adjourn ಆಯ್ತಲ್ಲ ಬೆಳಿಗ್ಗೆ?
12, sir.
Okay. 11.
Ajit PB.
None appears for the petitioner, call after 2 weeks.
My lord,
12 adjourn. 13,
Serial number
P.
11.
Krishna Bhatt.
Huh?
Serial number 11, my lords. We seek for a passover, my lords.
No passover, sir, I have adjourned it by 2 weeks.
My
Yes.
senior will come and argue, my lords. I was online, my lords.
Serial number 11 na?
Please, my lords. Ajit
Yeah.
PB.
Again, what is the urgency? 11, mister.
My lords,
Then online appear ಆಗ್ತಾವ್ರು petitioner.
my senior is before quota 11, my lords. He's asked for a passover, my lords.
ಅವ್ರಿಗೇನೋ passover ಬೇಕಂತೆ, serial number 11. Are you ready?
I'm ready.
ಆಯ್ತು 11 ಪಾಸ್ ಓವರ್ ಮಾಡಿ 11 ಪಾಸ್ ಓವರ್
12 adjourn. 13 Vijaya Krishna Bhatt, Bipin Negde.
Respondent, man.
None appears to the petitioner. Call up to 2 weeks.
14, 15, 16 adjourn. 17. 14
Time ತಗೊಂಡ್ರು.
time to petition advocate. 15 adjourn. 16 adjourn. 17 Pradeep Saukar.
Petitioner, please. Petition challenging the order passed on IA number 4 at annexure A, my lords.
MJ Alva.
There is the other side. None appears for respondent. Call after 2 weeks.
Short date, yakandre this is 2012.
I'll call next week.
Next week.
Next
I'm
week.
great.
18 Chandranath Ariga. Okay.
None appears to the parties. Call after 2 weeks.
19 Subhash Srinivas.
My lord, I appear for the respondent in this case, my lord.
Yeah.
This case has become infectious, my lord. The arbitration proceedings has been initiated and award is also being passed in this matter. So in this matter, my lord, the against an IA or in section 9 petition which was filed by the petitioner against the IA order against the IA number 3, this case was filed. However, the arbitration proceedings between the parties have been initiated and award is also, it's been concluded, award also been passed. Hence, this matter has become the infectious, my lord.
Have you produced the copy of the award counsel?
I shall place it, my lord. Actually, I'm for the respondent in this matter, but we shall place the order
No,
of
because
award copy.
petitioner is absent. Shall I pass it over? Can you come and produce the
Yes,
copy?
my lord. Yes, my
I
lord.
can dismiss it.
Yes, my lord.
I can
I'll
dismiss
come
it.
down and share. Yes, my lord.
We'll do it. Pass it over.
20 adjourn. 21 20 time notice. 21
Yes, release from party. Post the matter before appropriate bench.
My lord, it is substantially heard, my lord.
ಆಯ್ತ್ರಿ ಎಷ್ಟೊಂದು ಸಬ್ಸ್ಟಾನ್ಶಿಯಲಿ ಹರ್ಟ್ ಮಾಡಿದೀನಿ ಅದೆಲ್ಲ ಪಾಸ್
Pass it over, my lord, please.
ನೋ ಪಾಸ್ ಓವರ್
Ready, my lord.
ರಿಲೀಸ್
Wants to
ಫ್ರಮ್
make the
ಪಾರ್ಟಿ
submission.
ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟಿ post it before appropriate bench.
22 Raghavendra CR. Jeevan J Nilargi.
My lords, senior.
22, I appear for the petitioner's
Sir,
counsel.
are you ready, sir, or shall I release it from party? Let it go before the appropriate bench.
27
ಇದು
date.
KDP matter ಅಲ್ವಾ ಇದು?
ಹೌದು.
ಇಲ್ಲ sir. Tax.
KDP. Tax KDP.
27 ಕೊಟ್ಟಿದ್ರಿ ಡೇಟು, so we are not yet ready.
Early, sir, I'm in division bench now. I can't.
I understand.
That's the reason. That's the reason I am releasing all the matters also.
I leave it to the court.
Because I don't know when I will be sitting once again. That's the reason. Yes, release from party.
Please.
My lords, interim order.
Call next week. Interim order, if any, is extended till next date of hearing.
Please.
23
Obliged.
CM Nagbhushan.
Petition.
Yes, I think I'll reserve it.
Please, respondent.
Synopsis ಹಾಕಿದಾರಲ್ಲ? Yes, reserved. Reserved, sir.
I'll make further oral submission on this.
Sir, ದಯವಿಟ್ಟು writing ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ sir. I will consider those points.
ನಾನು ಹಾಕಿದ್ದೀನಿ. Even then I will be happy if your lordship we had me.
Sir, I heard you, sir.
No.
What more arguments can you canvass?
The question is only this, your lordship. As far as the conversion land is concerned, they are prepared to collect betterment charges for which our clients also are agreeable.
Yes, sir. Is it so?
Betterment charges, no? We have not made any submission.
23.5.
If it is,
Sorry, converted.
PM ನಾರಾಯಣಪ್ಪ ಅನ್ನೋ ಕೇಸ್ ನಲ್ಲಿ ನಾವು ಏನೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಅದರಲ್ಲಿ ಕಲೆಕ್ಟ್
ಆಗೋಯ್ತು ಸರ್ ಅದು.
ಅದಾಗೋಯ್ತು. ಬೇರೆ ಯಾವ್ದಿಲ್ಲ.
ಅಲ್ಲ ಒಂದೇ ಒಂದು ನಿಮಿಷ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ.
sir, listen, if it is converted, then if it is, unless it is essential for formation of road, leave it.
ಅಲ್ಲ ನಾವು ಅದು ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ದ ರೋಡ್ my lord, is under the CDP, my lord, the road is to be formed and my lord.
That's what I'm telling you. Unless it is required for the
My
formation of
lord,
the
if they
road.
want that, my lord, their occupation of the, my lord, remaining land should be, my lord, regularized. They can make a representation, my lord, then the board will consider and pass appropriate order.
Sir, as of now, if the lands are already converted for residential purposes, unless the land is required for formation of the road.
But my lord, we have also made clear in the affidavit that, my
Huh.
lord, in paragraph number 3, certain conditions are there for, my lord, giving up non-agricultural lands.
ಈಗ ಒನ್ ಬೈ ಒನ್ ಪ್ಯಾರಾ 3 ಕೆಳಗಡೆ ಯಾವ್ದು ಬರುತ್ತೆ? ಒನ್ ಬೈ ಒನ್ ಹೋಗೋಣ.
First matter.
ಬರ್ತೈತಿ ಇಲ್ಲ ಅಂತ ನಾವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ, my lord, you will also be direct the KHB to take a decision.
Sir, it can't be that way. They have come to the court, it's either setting aside or dismissing the writ petitions or partially allowing it.
Lord, since
Partially allowing it. Okay, now one by one we'll go. 23, land is converted or not? Sir, Nagbhushan sir,
yes, my lord.
23, land is converted or not?
Agriculture land.
Agri land, huh?
Agriculture lands is concerned, your lordship, I want to make a submission. It may take about 15 or half an hour.
Sir, I've heard substantially, sir. Dayavittu. Same thing, nan monne kuda nan last occasion also, I myself summarized because so many things were.
Filed a written synopsis and also.
I'll consider everything.
List of
If you want, I won't pronounce the judgment for 1 week.
Government.
You please file your synopsis. I will consider all those things and then only I'll pass orders. Yes, 23.1, is it agricultural land or?
Converted, it will totally come under paragraph 3 of the.
Para 3.
ಬರೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ my lord, I have submitted that the land claimed is, my lord, somewhere else. They say that they have established the brick factory. Brick factory is not established in the converted land. We have filed a memo along with, my lord, necessary material for your lordship's consideration. A synopsis
That also I made by submission, my lord.
ಅದು ಬರಲ್ಲ ಅಂತ ನಮ್ಮ submission. ಅದಕ್ಕೆ ನಾವು we have filed a memo also, my lord, showing that it is in some other place. Conversion order is there, but it is not utilized for the purpose for which they are claiming.
In their statement of objection, they clearly admit my ownership, conversion and the formation and other existence of the factory there. Brick factory. All these things they have admitted in their statement of objections. I have also referred to that in my.
Yes, sir. 23.2.
Nagbhushan sir.
It's an agricultural land, my lord.
Agricultural land.
23.2.
Yes, 23.3.
ಅದು agriculture.
Next project.
23.4.
23.4 ಅಲ್ಲಿ ನೋಡ partially agriculture, partially converted. Not in that, my lord, on part petition number 7 dated, I am filing an application, certain copies also, that may be allowed, and amendment only for extent of the small extent is variation. I may permit to amend it also. I have certain copies.
ಈ ಅಂತ amendments.
ಅಲ್ಲ, ಒಬ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ, ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ಟು ಅಫಿಡವಿಟ್ ಇದು ರೆಡಿ.
ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ?
ಪಿಟಿಷನ್ ನಂಬರ್ 7 ಸತ್ತೋಗಿದ್ದಾರೆ, ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತಾ ಇದೆ.
Petitioner, the advocate for the petitioner submits that petitioner number 7 died on.
Died on 16/9/2016. 16/9/2016.
16/9/2016. Huh.
Applications filed to condone and delay, setting upper side and LR application.
Application for?
Condonation delay.
16/9/2016.
Set aside amendment.
Applications ತಗೊಳ್ಳಿ.
ಮೂರು
He has filed the necessary application to bring the legal representatives of deceased petitioner number 7 on record, and also necessary application. Petition.
Ready. I also filing
ಒಂದು objection ಹಾಕಿರ್ಲಿಲ್ಲ ಫಾರ್ಮಲ್.
ಇದರಲ್ಲಿ ಪಾರ್ಟ್ ಕನ್ವರ್ಟೆಡ್ ಪಾರ್ಟ್ ಅಗ್ರಿಕಲ್ಚರ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಇದ್ರ ಇನ್ನೊಂದು 616. I'm filing an application, amend the writ petition. Only extent ಅನ್ನೋದು ಪಾಡಿನಲ್ಲಿ ಕರೆಕ್ಟ್ ಅರ್ಧ ಗುಂಟೆ ಬಿಟ್ಟು ಹೋಗಿದೆ, that may be allowed. I have served copies also. I will correct it.
Full stop. He has also filed next to, he has also filed an application to amend the writ petition on the ground that there is a typographical error in mentioning the extent of the land of the petitioner which is sought to be acquired.
And the name of the one person, alias name.
Full stop. Accepting the caution, the same is hereby allowed. Petitioner is directed to amend the writ petition and file amended
Yes,
petition
ready, sir.
forthwith. Yes,
ಕೊಡ್ತೀನಿ.
ನಮ್ದೊಂದು objection ಹಾಕಿ sir.
ಆಯ್ತು sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ
The objection filed by respondent to the writ petition is taken on record. Yes, part agricultural, part converted.
ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ ಎಲ್ಲ ಕನ್ವರ್ಟೆಡ್ ಅಂತ ಬರ್ತಾರೆ. ಮೆಮೋ ಇವೆಲ್ಲ ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ ಎಲ್ಲ ಕನ್ವರ್ಟೆಡ್ ಅಂತಾನೆ ಬರ್ದಾರೆ.
ಅಲ್ಲ ಸರ್, ಕೆಲವು ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಇದಾವೆ. ತಾವಿದ್ದೀರ ಅದ್ರಲ್ಲಿ.
ಪಾರ್ಟ್ಲಿ ಕನ್ವರ್ಟೆಡ್, ಪಾರ್ಟ್ಲಿ ಅಗ್ರಿಕಲ್ಚರ್.
ಲಿಂಗಣ್ಣ,
ಸಾರಿ ಹಂಗಾದ್ರೆ
ನಿಮ್ದು ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ ಎಲ್ಲ ಕನ್ವರ್ಟೆಡ್ ಅಲ್ವಾ?
ಅದು ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ ಸರ್, ಯಾವ್ದು ಕನ್ವರ್ಟ್ ಆಗಿದೆ ಯಾವ್ದು ಕನ್ವರ್ಟ್ ಆಗಿಲ್ಲ ಅದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ. ಓಕೆ,
ಅಲ್ಲ ಅದನ್ನ ಡಿಸ್ಪೋಸ್
ಮಾಡ್ಕೊಂಡ್ರೆ
ಇದರಲ್ಲಿ WP ನಂಬರ್ 3245 ನಲ್ಲಿ ಎಲ್ಲಾ ಲ್ಯಾಂಡ್ ಗಳು ಕನ್ವರ್ಟೆಡ್ ಅಂತ ನಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ.
ಅದನ್ನ ದಯವಿಟ್ಟು ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ. ಓಕೆ, ಎಸ್ ಸರ್, the order is going to be, I am telling the order now itself. The order is going to be converted lands. I am quashing the acquisition proceedings.
No, my lord, we have objections for that because
Sir,
for this reason.
Sir, ಪೂರ್ತಿ ಹೇಳೋದು ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಸರ್. Converted land, I am quashing the acquisition proceedings, excluding the land required for formation of the road connecting with the other area where the layout is
Roads and
being
civic communities and
okay.
roads and civic communities. Roads and civic communities.
ಕೊಡ್ತಾ ಇಲ್ಲ.
Roads.
Civic communities ನೀವು ಬೇರೆ ಕಡೆ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರಿ.
ಕನೆಕ್ಟಿಂಗ್ ರೋಡಿಗೆ ಮಾತ್ರ ಕೊಡ್ತಾ ಇರೋದು.
ಆಮೇಲೆ some of the petitioners with respect to converted lands, they have come with a proposal requesting the housing board to accept the betterment charges and regularize. As per Nadbidi Ram Reddy's case.
ಅದೆಲ್ಲ ಮಾಡಿ.
That we shall do. That we shall do subject to formation of roads. Subject to formation of roads. Lord, they have filed the memo in 23.5.
ಅದ್ರ ನೀವು ಇವರು ಇರೋದು ಲಿಂಗಣ್ಣ ಕೇಸಲ್ಲಿ ಯಾರು ಇರೋದು? ನೀವು ಕೂತ್ಬಿಡಿ.
Yes. ಆ ಕೇಸ್ಲೋ ಇಸ್ಕೊಳ್ಳಿ, ಆ ಕೇಸ್ಲೋ ಕೊಡಿ.
ನಡುಬಿದಿ.
Yes, 23.5. What is this land?
Sorry. Lord, 23.5. So this Muniappa, they are contending that petitioner submitted KHB has taken a decision to collect the developmental betterment charges and to regularize such
Converted
lands.
or non-converted, sir?
Converted.
Converted.
Arda converted, arda agriculture land.
ನೋಡಿ, ಬಿಫೋರ್ ದಟ್ ಮಲಾಡ್
ಸರ್ವೆ ನಂಬರ್
23.5 ಕಂಪ್ಲೀಟ್ ಆಗಲಿಲ್ಲ. 23.5 ಅಲ್ಲಿ ನಾವು ಮೆಮೋ ಆಗ್ತಾ ಇದೆ.
23.4 or 23.5?
23.5 ಸಾಹೇಬರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
23.4 ನೋಡಿ, ಅವ ಫೈಲಿಂಗ್ ಮೆಮೋ ಕನ್ವರ್ಟ್ ಲ್ಯಾಂಡ್ ಬೆಟರ್ಮೆಂಟ್ ಚಾರ್ಜ್ ಅಗ್ರಿಕಲ್ಚರ್ 50-50 ಶೇರ್ ಮಾಡ್ಕೊಂತಾರೆ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ವಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು.
You want 50-50?
ಅಲ್ಲ, ಇದು ಸೋಫಾರ್ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಕನ್ವರ್ಟೆಡ್ಗೆ ಬೆಟರ್ಮೆಂಟ್ ಚಾರ್ಜ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕಂದ್ರೆ ಸರ್ವ್ ಮಾಡಿದ್ದು ಮುಂಚೆನೆ.
ನಿಮ್ದು
ಆಗ್ಬೋದೇನ್ರಿ
ಲಿಂಗಣ್ಣ?
ಸರ್ ಆಗ್ಬೋದಾ? Who appears 23.4?
extent ಗೆ my lord will consider.
Sir, what they are stating is converted land betterment charges ಕಟ್ಕೊಂಡು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ 50-50 ಶೇರಿಂಗ್ ರೆಡಿ ಇದಾರೆ. ಮಾಡ್ಬೋದಾ ಆರ್ಡರ್?
ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಇಲ್ಲ, ಆ ಲ್ಯಾಂಡ್
ಇದೆ.
50-50 agreeable.
You agree for it? ಬರ್ಕೊಳ್ಳಿ 23.4 ಅಲ್ಲಿ. after arguing the matter for some time, the advocate for the petitioner submits that part of the land which is the subject matter of the writ petition have been converted for residential, non-agricultural purposes. And part of the land is agricultural purposes. Full stop. He further submits that they have given a proposal to the respondent Karnataka Housing Board that the converted land may be left out from acquisition and that they are willing to pay betterment charges for the same. Full stop. It is further submitted that in respect of agricultural land, the petitioners are willing to
Part of the land part.
take 50% of the developed sites
In lieu of monetary compensation.
in lieu of monetary compensation, in lieu of monetary compensation, in lieu of monetary compensation, and they have submitted and they have requested the KHB to pass an award accordingly. Full stop. Next para. The learned counsel for senior counsel for KHB.
We are ready to
Tavo Yura.
50-50.
Tavana.
50-50 consider.
Sabrat, huh? Submits that they are agreeable for the said proposal.
No, agriculture land in ಬಗ್ಗೆ ಅವರು ಹೇಳಿರೋದು agreeable ಇದೆ.
ಅಲ್ಲ ಸರ್.
Converted land.
Converted land building ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ಅಷ್ಟೇ ನಾವು regularize ಮಾಡಿ betterment charge.
Sorry, judgment ಹಾಕೊಳ್ಳಿ. ಇದು ನೋಟ್ ರೆಡಿ ಮಾಡಿ ನಾನು ಜಜ್ಮೆಂಟ್ ಪಾಸ್ ಮಾಡ್ತೀನಿ. I'll pass the judgment, sir.
50-50 milord agriculture land milord we can consider.
Yes, sir.
ರಿಟರ್ನ್ಸ್ ಆಪ್ಷನ್ಸ್ ಆ ಕೇಸಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
ಕೊಡಿ. Yes. Consent ಇಲ್ಲ. So we'll pass the judgment.
ಅದನ್ನು ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ ಇದಾರೆ. ಆ instructions I am submitting that agriculture land non-agriculture land ಗೆ ಇದನ್ನ betterment charges ತಗೊಂಡು ಕೊಡೋದಕ್ಕೆ ರೆಡಿ.
ನೀವು ಎಸ್ ಅಂದ್ರೆ ನಿಮ್ಮ
ಅವರು ಇಲ್ಲಿದ್ದಾರೆ ಅವರ instructions ಎಲ್ಲನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅದನ್ನ ಹಂಗಾರೆ ಬರ್ಕೊಳ್ಳಿ.
I am submitting.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಏನ್ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿ.
The senior counsel for KHB upon instructions submits that the Karnataka Housing Board is agreeable for the proposal submitted by the petitioners. Submitted by the petitioners. Full stop. Hence the following order. ಅಲ್ಲಿ ಅದು ರೋಡ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ವಾ?
Road ಇದೆ.
Except the extent of land which comes for the formation of road ಅಂತ.
ಹೋಗ್ಲೇ ಅಂತಾರೆ ಅಷ್ಟೇ. ಹೋಗದೆ ಉಳಿದಿದ್ರು
ಅಲ್ಲಿ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಮೇಲೆ ಹಾಕೊಳ್ಳಿ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಹೆನ್ಸ್ ಏನ್ ಬಂತೀಗ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ proposal of the petitioners. Petitioners, full stop. Next para.
Except
the counsel for petitioner and petitioners and the KHP further together further submit that petitioners have no objection for formation of for acquiring the land in for acquiring a portion of the converted land which is essential for formation of road to connect the other areas where the KHB is forming a layout.
Yes.
Subject to they have to pay compensation or just
road
and that KHB shall pay the necessary compensation for the same.
Or adjustment of lands in the remaining lands.
Either by way of monetary compensation or alternative site,
land.
as per the policy of the state. As per the as monetary compensation or allocation of developed sites as per the policy of the state. Full stop. Hence the following order. Writ petition is disposed of with a direction to the KHB. Writ petition is disposed of. Writ petition is allowed in part. Hence the following order. Writ petition is allowed in part. The acquisition of the converted land belonging to the petitioners, which is the subject matter of the writ petition, except the land required for formation of the road to connect other areas where the respondent KHP is forming a layout is hereby set aside, subject to petitioners paying the necessary developmental charges. Developmental charges, correct?
Betterment.
ಅಲ್ಲ betterment charges.
Betterment charges to the KHB. Full stop. Next para. The writ petition pertaining to the writ petition insofar as it relates to
Agriculture.
the challenge in respect of the agricultural lands is hereby dismissed, reserving the liberty to the petitioners to claim compensation from KHB in terms of
50-50.
in terms of developed sites in lieu of monetary compensation as per the policy of the state and KHB.
I may be pardoned, my lord.
Yes, sir.
Lordship may kindly dispose of this matter in terms of paragraph 4, my lord, which is a.
Sir, ಇದ್ರಲ್ಲಿ ಏನ್ ತಪ್ಪಿದೆ ಇವಾಗ ಮಾಡಿರೋದು ನಾನು?
Set aside ಮೇಲ್ಗಡೆ ಕನ್ವರ್ಟೆಡ್ ಲ್ಯಾಂಡ್
ತಾವೇ ಮಾಡಿ.
ನಡುಬೀದಿ ರಾಮಯ್ಯ's case.
In terms of that earlier order.
In terms of that order.
ಅಲ್ಲ
Set aside ಅಂತ ಬೇಡ.
ನಡುಬೀದಿ ರಾಮಯ್ಯ.
ನೀವು ಮಾಡ್ಬೋದಲ್ಲ ಈ ತರ?
ಅಲ್ಲೇ ಅವರೇ ಇದ್ದಾರೆ.
ಈ ತರ ಮಾಡ್ಬೋದು ತಾನ?
ಆಗ್ಬೋದು.
ಒಂದು ಅದನ್ನ ಅದು ಆಪರೇಟಿವ್
As per the law laid down in that case.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಆರ್ಡರ್ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡುವ. ಆಸ್ ಪರ್ WP ನಂಬರ್ 13603 of 2014 ಅಂತ ಬರ್ಕೊಂಡಿರಿ. ನಂಗೆ ಹೇಳಿ ಚೇಂಬರ್ಸ್ ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ. I'll do it, sir.
Please.
Okay.
Only in respect of converted.
Yeah. ಎಲ್ಲ ರಿಸರ್ವ್ ಅಂತಾನೆ ಮಾಡಿ ಎಲ್ಲ. ಇದು 23.6 ಮೇಡಮ್.
23.5 ಅಲ್ಲಿ
23.5.
23.5. This is one land that is 1 acre 33 guntas in survey number 29/2. I is converted and survey number 33/1 of Konsandra I are converted. So far as converted lands, they have filed a memo adopting the law laid down in Nadubidi Ramaya's case, for which we have no objection.
ಇದು ಅಗ್ರಿ ಮತ್ತು ಕನ್ವರ್ಟೆಡ್ ಅಲ್ವಾ?
ಯಾವುದು?
ಪಾರ್ಟಿ ಅಗ್ರಿ.
ಅಂಡ್ ಏನಂದ್ರೆ 45 meters ರೋಡ್ ಬರ್ತಾ ಇದೆ, ಎಕ್ಸೆಪ್ಟ್ ದಟ್.
ಆಯ್ತು, ಇದನ್ನು ಅಗ್ರಿಕಲ್ಚರಲ್ ಕನ್ವರ್ಟೆಡ್ ರೋಡ್
ಅಲ್ಲ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಗೆ ಶೇರಿಂಗ್
ಲ್ಯಾಂಡ್ ಶೇರಿಂಗ್
ಶೇರಿಂಗ್
ಡೆವಲಪ್ಡ್ ಲ್ಯಾಂಡ್ ಎಕ್ಸೆಪ್ಟ್ ರೋಡ್
ಬಿಲ್ಡಿಂಗ್ ಇರೋಕ್ ಮಾತ್ರ ಬೆಟರ್ಮೆಂಟ್ ಕಟ್ತೇವೆ. ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಗೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ.
ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಗಿದೆ.
ಅದು ಅಷ್ಟೇ, ಅದ್ರ ಮೇಲೆ ಅಷ್ಟೇ ಸರ್.
ಲ್ಯಾಂಡ್ ಶೇರಿಂಗ್ ಒಪ್ಕೊಂಡಿದ್ದೀರಿ?
23.3 ನಲ್ಲಿ
ಲ್ಯಾಂಡ್ ಶೇರಿಂಗ್ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ?
ಇದ್ರಲ್ಲಿ
ಒಪ್ಪಿಲ್ಲ ಅಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಓಕೆ, ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ದ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. ಕನ್ವರ್ಟೆಡ್ ಬೆಟರ್ಮೆಂಟ್, ಆಮೇಲೆ ರೋಡ್. ಓಕೆ ಫೈನ್. 23.6.
23.3
ಇದು
There is a 80 feet road, my lords. We have already given up that land. KHP has taken for the road is formed. So, my lords, we are requesting, my lords, if any betterment, I have not filed a memo, I'll file a memo, my lords, that if betterment charges.
if they file, if they make a request, we will consider it.
Betterment charges.
Betterment charges. Except the land which is required for formation of roads.
Compensation is HB.
ಓಕೆ. ಇದು KDB ಅಂಡರ್ಟೇಕಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. KDB ಅಂಡರ್ಟೇಕಿಂಗ್ ಬೈ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. KHB ಅಂಡರ್ಟೇಕಿಂಗ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಪಾನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. Leave out the land from acquisition by collecting betterment charges.
Except the
ಆಮೇಲೆ ಡ್ಯಾಶ್ ಹಾಕ್ಬಿಟ್ಟು ವೆಲ್ನೆಸ್ ಸೆಂಟರ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್ by taking necessary panchayat permission. Next,
23.
road already left that is required for formation of the road and the same is not in dispute. Correct alla sir?
compensation ಅಂತ
Yes sir.
same in the, as per the law laid down by your lordship Nadubidi Ramaya's case, we are agreeable in all the cases.
No, here conversion ಆಗಿಲ್ಲ. That's the reason.
ಇದು ಕನ್ವರ್ಷನ್ ಆಗಿಲ್ಲ, ಆಶ್ರಮ ಅವರು ಧಾರ್ಮಿಕ ಕಾರ್ಯಕ್ರಮಗಳು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ we have accepted principally to collect the betterment charges, but except the area which comes in the way of forming the road.
Yeah, that's
All right, except that.
okay. Okay. Compensation paid to be paid.
ಅದು ಆರ್ಡರ್ನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿದ್ರೆ ಬೆಟರ್.
Compensation for road.
Except the area comes in formation of road ಅಂತ.
Compensation to be paid for the road. ಬರ್ಕೊಳ್ಳಿ. Compensation to be paid for the road. ಅಷ್ಟೇ, ಅದು ಸಾಕು. Yes, 23.7.
All others are agricultural land, my lord, and I am filing a
Sure, sir.
citations.
23 to 23.7 to 14 all agricultural lands.
Yes, your lord. 23.3 also agricultural land.
ಅಲ್ಲ 23.7 ಇಂದ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಮುಗೀತಲ್ಲ.
Sorry, sorry. 23.7 ನಲ್ಲಿ ಆಗಿಲ್ಲ.
23.7.
Okay, one by one ಹೋಗೋಣ. 23.7 agri land.
Agriculture land. Okay, we are agreeable for giving 50-50 ratio.
They agree.
If they are
Yes.
agreeing.
23.8.
23.7 agriculture land ಅಷ್ಟೇ, agreement ಆಗಿಲ್ಲ ಅದು.
ಆಯ್ತು, okay.
Merits ಮೇಲೆ ಅಷ್ಟೇ.
ಅದರಲ್ಲಿ
23.8.
some of the petitioners have come forward.
ಹೋಗಿದೆ ಸರ್ ಅದು. Dispose ಆಗ್ಬಿಟ್ಟಿದೆ ಸರ್ ಅದು.
ಅದರಲ್ಲಿ so many persons are included in their writ petition.
Okay,
Some of
23.8.
them have filed the
ಯಾರು
affidavit.
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಸರ್.
ಆಯ್ತು, 23.8 ಅದು.
ಅದು ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್.
23.9.
Agriculture land.
23.10.
Agriculture land.
11.
Converted.
I am
Partly converted, partly agriculture.
Lord Nadubidi Ramana and my lord 50.
Okay.
My lord, in this matter, my lord, there are two kinds of land. One is agricultural land, one is converted land, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
23.11.
23.11. Yes.
And also, my lord, first, my lord, this has been converted as a residential zone. Again, they have converted into industrial zone, my lord. And again, they have changed from industrial zone to residential.
That's
zone.
okay.
No,
Sir,
I have paid betterment charges. That is Rs 1,90,000.
Sir, converted lands, we are setting it as Nadubidi, the other case of
Yes,
Ram
yes.
Reddy.
Nearly 5 lakhs rupees I have paid, my lord. For
Okay.
conversion as well.
Okay, fine. 23.12.
Lord, in this.
Huh? Agri land, okay.
In this case.
Madam.
Judgment. Lord,
Okay.
Lord, the petitioners.
ಏನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ ಅಲ್ಲೇ? ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಮನೆ ಕಟ್ಟಿದ್ವಿ, ರೇಷ್ಮೆ ಬೆಳಿತಾ ಇದ್ದೀವಿ. ಇದೆ.
50-50ಗೆ ಒಪ್ಕೊಂತೀರಾ?
ನಮ್ಮ ಸಂಸಾರ ನಂಬರ್
50-50ಗೆ ಒಪ್ಕೊಂತೀರಾ? ಸರ್, ಅವರು 50-50ಗೆ ಒಪ್ಕೊಂತಾ ಇದಾರೆ. ಅವ್ರ ಮನೆ ಕಟ್ಕೊಂಡಿದಾರಂತೆ. ಆ 50-50 ನಲ್ಲಿ ನೀವೇನ್ ಬಿಡ್ತೀರಾ? ಅವ್ರ ಮನೆ ಇರೋ ಜಾಗ ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
Yes. ಆಯ್ತು, ಅಲ್ಲೇ ಕೊಡೋಣ. ಅದನ್ನ ರೆಗ್ಯುಲರ್ let them give representation to that effect. With all the details, we will consider it. Lord, in this case, apart from that, petitioners 1, 3, 4, 14, 15, 20, 27, 28, they have withdrawn.
Okay, it's all right. 23.13.
Agriculture land.
Agri land, okay. 23.14.
My lords, for 23.14, there are 2 schedules, my lords, out of 20 schedules. Only 2 properties are converted, but in both cases, my lords, they are subsequent purchases. So the writ is not maintainable at their instance, my lords.
Sir, it's all right. The point is, KHB is fairly submitting that wherever it is converted, they are collecting the betterment charges and allowing it. Why do you want to come in the way?
My lords, in this instance, that portion of the land falls within the CDP, my lords, CDP road, my lords. To both the grounds are applicable.
That we are not going to quash.
Yes, my lords.
Okay.
So but they are subsequent purchases, my lord. So during the pendency of the writ petition.
It's okay, we'll not highlight that. See, anyway, you're leaving it out. Be fair, man, leave it out.
I will just.
Your KSB officials over here, you are sitting in your cozy confines of your.
No, my lord,
office and
today I
archive.
had to travel out for another matter, so.
Okay, it's all right. You ask your KSB officers, ask your KSB officers and say, sir.
Yes, my lord, I'll do that.
I may be permitted to leave.
Betterment,
Yes, sir, please.
betterment charge ತಗೋಬಹುದು ಅಂತ ಹೇಳಿ.
Okay, I'll pass the order now itself.
ನಡುಬೀದಿ ರಾಮಣ್ಣ ಅಂತ ಹೇಳಿ ಅವ್ರು
ಕೊಡಿ ನಡು ಬೀದಿ ಕೊಡಿ.
ಆಮೇಲೆ one submission my lord 23.3 ಅಲ್ಲಿ my lords I want to make one submission. 20.3 ನಲ್ಲಿ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ ಫಾರ್ಮಲಿ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
ಆಯ್ತು 23.3 ನಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಷ್ಟೇ.
23.5 ನಲ್ಲಿ ಮೆಮೊ ಆಗ್ತಾ ಇದೀನಿ ವಾಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಐ ಸಬ್ಮಿಟ್ ಐ ಆಮ್ ಫೈಲಿಂಗ್.
ಆಯ್ತು ಸರ್, ಓಕೆ, I'll pass my orders.
23.5 ಆಮೇಲೆ 23.1 ನಲ್ಲಿ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬೇಕಾಗಿ ಸ್ವಾಮಿ, ಮೈ ಅಪಾಲಜೀಸ್ ಬೈ ಮಿಸ್ಟೇಕ್.
ಹಾಕಿ ಸರ್.
23.1
ನಂಬರ್ ಇದೆಯಲ್ಲ ಬಿಡಿ ಸರ್, ಬರ್ಕೋತಾರೆ.
All converted properties, my lord,
One
in
single
terms
order
of-
ಮಾಡಿ.
my lord, in respect of converted, my lord, the lands, Lord may kindly, my lord, pass orders in terms of Nadubidi Ramanna's case, my lord. That covers all the, my lord, submission. ನಾವೇ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಪ್ಯಾರಾ 4 ನಲ್ಲಿ ಆ ಪ್ರಕಾರ ಮಾಡಿದ್ವಿ.
So this may not be appropriate.
ಅಲ್ಲ ತಾವು ಎಲ್ಲಾ ಕೇಸ್ಗೂ ಇಟ್ ಇಸ್ ಅಪ್ಲಿಕೇಬಲ್.
ಅಲ್ಲ, correct. This is in so far as agricultural lands are concerned.
ಎರಡು ಇದೆ.
One first, my lord, resolution is for, my lord, agriculture land. Second resolution, which is, my lord, extracted, my lord, in the third page, it is in so far as, my lord, converted land.
ಎಲ್ಲಿದೆ ಹೇಳಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸರ್? ಇಲ್ಲಿ 40% ಬರುತ್ತೆ ಸರ್, 40% ಬರುತ್ತೆ ಸರ್, 50% ಅಲ್ಲ. ನೀವು 50% ಕೊಡ್ತಾ ಇದ್ದೀರಿ.
ಇಲ್ಲ 50%
ಆ ಕೇಸಲ್ಲಿ, my lord, that is third, second phase, my lord, this is fourth phase. ಇದಕ್ಕೆ 50% ಮಾಡಿದ್ದಾರೆ ಗವರ್ಮೆಂಟ್.
I'll pass my order, sir. If you are agreed, please go on and appeal. That's all. Yes, ಬನ್ನಿ. ಇದು ಕಂಬೈನ್ಡ್ ಆರ್ಡರ್ ಮಾಡಿ, ಕಾಮನ್ ಆರ್ಡರ್. The present writ petitions are filed challenging the act of the state and the Karnataka Housing Board for acquiring the lands belonging to the petitioners for the purposes of Karnataka Housing Board. So Karnataka Housing Board to form a layout. Full stop. The preliminary notification is issued on ಯಾವಾಗ ಡೇಟ್? Preliminary notification under what provision it is issued?
Land Acquisition Act.
Land Acquisition Act, 4(1) of the land.
Under section 4(1) of the Land Acquisition Act has been issued on 19/10/2013, and the final notification under section 6(1) of the Land Acquisition Act has been issued on
12/3/2015.
12/3/2015. Full stop. Full stop. The acquisition, the notifications, awards pass ಆಗಿದೆಯಾ?
ಹಲೋ, 2 ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
The acquisitions and as well as the awards have been passed in the manner known to law. Possession ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿವಿ. ಎಲ್ಲೆಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಎಲ್ಲ ತಗೊಂಡು.
Possessions also have been, possession of the lands also have been.
ತಗೊಂಡಿಲ್ಲ, ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಅದು ಮೆಮೊ ಹಾಕಿ ಸ್ವಾಮಿ ನಾವು. How that award is not proper ಅಂತ. We are given a details.
ಸ್ಟೇ ಇರೋದಕ್ಕೆ ಅವಾರ್ಡ್ ಆಗಿಲ್ಲ. ಸ್ಟೇ ಎಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಅವಾರ್ಡ್ ಆಗಿಲ್ಲ.
Possessions also have been taken, possession of the lands have been taken in accordance with law in those writ petitions where there have been no interim orders. Huh?
Yes.
Interim orders. ಮೇಲ್ಗಡೆ award ಏನ್ ಬಂತು? ಮೇಲ್ಗಡೆ ಒಂದ್ ಪ್ಯಾರ award ಒಂದ್ sentence award ಬಗ್ಗೆ ಬಂತಲ್ಲ. ಏನ್ ಬಂತ ಹೇಳಿ?
40-60.
Award has been passed in accordance with law. Known to law. Full stop. However, awards have not been passed in those matters where there have been interim orders. ಅದು ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಇದು ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಹೇಳಿ. Full stop. In the aforementioned writ petitions, some of the lands have been converted for non-agricultural residential / industrial purposes. Non-agricultural, while some of the other lands have been are of agricultural in nature. Agricultural in nature. Full stop. ಯಾವ್ದಾದ್ರು ಒಂದು writ petition ಕೊಡಿ. In WP number 42394 of 2015, the petitioners have established a wellness center. Though the land has not been converted for non-agricultural purposes. Full stop. Next para. The counsel for the counsel for the petitioners submit that the lands fall within the eco-sensitive zone and the same could not have been acquired for formation of a layout. Number one, for formation of a layout. Full stop. It is further submitted. It is further submitted the respondents without considering some of the lands being converted for residential or industrial purposes have gone ahead with the acquisition. Full stop. It is also submitted that respondents are acquiring the lands for formation of a residential layout, and they ought to have left out the lands which have already been converted for the same purpose or industrial purposes. Full stop. Next para. In respect of agricultural lands, it is submitted that the petitioners have no other source of income and are exclusively dependent upon the agricultural produce in the said land.
The 5A inquiry is not done properly. That is our main contention.
Even 5A inquiry.
Your Lordship may take our notes of submission, my lord.
Notes of my submission are right.
ನಾವು ಹೇಳಿದ್ವಿ ಯಾವತ್ತಾವತ್ತು ಏನೇನು ಡೇಟ್ ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳಿದ್ವಿ.
ಹಾಕಿದೀವಿ. What has been done?
And I'll take decisions also.
On that point.
Right. Okay. Section 5A na?
ಹೌದು.
5A.
Kudi, Section 5A kudi. Land Acquisition Act
ಹೌದು.
kudi.
Your Lordship take our notes of submission, first case.
ಆಯ್ತು ಒಂದು ನಿಮಿಷ 5A ನೋಡೋಣ.
Notes of submission ಕೊಡಿ sir.
Notes of submission.
Okay, sir, I'll consider that. ಏನ್ ಬಂತ ಹೇಳಿ? Full stop. It is also submitted that they have no other it is also submitted that they have no other skills other than doing agriculture, and acquiring the land would result in them being deprived of their right to life, their right to livelihood, right to livelihood. Full stop. It is also submitted that the layout is being formed when other layouts formed by KHB it is further submitted that a layout is sought to be formed on the lands of the petitioners when sites in other layouts formed by KHB have not been sold. And it is not to cater to the housing purposes of the homeless, but for allotting the sites for speculative purposes to other persons. Full stop. It is also contended that inquiry as contemplated on section 5 capital A of the Land Acquisition Act has not been conducted in the manner known to law. Full stop. For the aforementioned reasons, it is prayed that the acquisition in respect of the land's consent be set aside. Full stop. Next para.
Further, my lord. Clearance ತಗೊಂಡಿದ್ದೀವಿ ಅಂತ ಹೇಳಿರಲ್ಲ ಅವರು ಈ ಲ್ಯಾಂಡ್ಸ್ ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ because in the document all the lands where disputes are there they never taken, that's not there in the clearance certificate, my lord. Because they made a statement, no.
Your lordships have heard us, my lord. And my lord, in some cases, my lords have allowed the writ petitions partly, my lord, and your lordship we have filed the synopsis.
Have you taken clearance or
No, my lord, no.
Synopsis is most misleading.
All clearance ತಗೊಂಡಿದ್ದೀವಿ ಎಲ್ಲ clear.
And our synopsis.
yes, okay sir, per contra the counsel for respondents justify the acquisition of the land's consent. Full stop. However, in course of arguments, the counsel for the learned senior counsel for counsels for KHB, Shri so and so and Shri so and so, okay, upon instructions submit that in all cases where the lands have been acquired, where the lands have already been converted for residential or industrial purposes, the same shall be left out from acquisition subject to the petitioners paying betterment charges. Full stop. However, they submit
ಎಲ್ಲ ಕೇಸ್ನಲ್ಲಿ
Regularize ಅಂತ ಹೇಳು. Left out ಅಂತ.
has to be left out. However, however, it is they further submit. However, they submit that certain converted lands are required for formation of roads as per the comprehensive development plan to connect the same, to connect the connect Bannergad
without pen.
link the other layouts of KHB
R6.
with that of main roads, and the area required for formation of such roads cannot be left out from acquisition, even though the same are converted. Full stop. With regard to agricultural land, they submit that with regard to agricultural land. However, in WP number 42394 of 2015, though the land is not converted for agricultural purposes, in the light of establishment of a wellness center, the learned Shri so and so learned counsel for KHB upon instructions submit the land will be left out from acquisition subject to petitioner paying the betterment charges, and only the land required for formation of the road will be acquired.
But
Full stop.
shall now be 45 meter ಅಂತ ಹೇಳ್ತಾರೆ, that is not necessary according to them.
ನಮ್ ಕೇಸಲ್ಲಿ 23.
Sir, CDP ಅಂತ ಹೇಳಿದೀನಿ ಸರ್, CDP and to connect other areas ಅಂತ ಹೇಳಿದೀನಿ. ಈಗ ನಿಮ್ದು ಇಂಟರ್ನಲ್ ರೋಡ್ಸ್ಗೆಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
ನಮ್ದು 23.5 ಅಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಎಡ್ಜ್ ಅಲ್ಲಿ ಇದೆ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Sir, please hear the order. Yes. Full stop. Next para. In respect of agricultural land, it is submitted that the land do not fall under the eco-sensitive zone as contended by the petitioners, and necessary clearances have been taken from the government, and documents are produced to show the same. Full stop. It is further submitted that the lands are that in the light of the city of Bangalore growing, there is a requirement for housing purposes, and care is taken by the authorities concerned to allot the sites only to those who do not have a site in Bangalore. In Bangalore. Huh?
In the state and entire state, my lord. It is in entire state. As per the rules, my lord, we should not be owning a site in the
Okay,
state.
in the state of Karnataka, their submission is placed on record.
One more submission is that, my lord, what we have acquired is, my lord, around 1,938 acres. My lord, only a small portion
Yes,
of the land.
it is further submitted in and around the lands which are the subject matter of writ petition, an area of
1,938, my lord,
1,938 acres of land is acquired
under the final notification.
under the final notification, and only a few of the
Small fraction.
landlords are before the court. Full stop. It is also submitted that most of the lands which are the subject matter of the writ petition lie at the mouth of the layout sought to be formed, and it is very essential that the lands are required to be acquired for better connectivity.
They have also raised a discrimination, middle of the layout. They have given up the lands.
Okay, sir. Yes, full stop. It is also submitted that the land has been acquired by the state in excess of its the power under eminent domain, in excess of its power of eminent domain, and is essential and the petitioners not having any alternative land is not a ground for setting aside the acquisition proceedings. Full stop. It is also submitted that the state is always, the respondents are always ready and willing to pay just and fair compensation to the petitioners. Full stop. It is also submitted that if the petitioners are desirous of developed land in lieu of monetary compensation, the same shall be paid to them as per the policy of the state / Karnataka Housing Board. Full stop. For the said reasons, it is prayed that the writ petitions be dismissed. Full stop. Next para.
One sudden submission. We have actually not accepted to exclude, my lord, all the lands that are converted. My lord, for example, in Mr. Shashi Kumar's case, my lord, Satyanarayan, our submission is that, my lord, it does not come within the purview of, my lord, para 3, because the converted land is not used, but the brick factory is established in some other portion.
Okay. Next para. In respect of WP number 29696 of 2015, it is submitted.
With detailed documents.
It is submitted that though the land is converted for industrial purposes, no industry is established on the land concerned as contended by the petitioners, and it is established elsewhere. Full stop. It is prayed that the said writ petition be dismissed. It's all right, Ray. Dismissed. Full stop. Next para. In the light of the aforementioned submissions made by the petitioners as well as a respondent, it is clear that some of the lands which are the subject matter of the writ petition are agricultural lands, while some of the other lands are converted for industrial or residential purposes. Full stop. Next para. Karnataka Housing Board is an institution established under ಯಾವ act, sir?
Karnataka Housing Code Act 1962. Section 5.
Karnataka Housing Board Act 1962.
Final ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್.
And he is established to provide quality and affordable housing accommodation to all sections of the society. Stop. Huh? Sir, I have heard you, sir. I am dictating my orders.
One hour list
The required permissions from the respective government
has not taken.
has not been taken. It is been taken on 3/6/2023.
Okay, sir.
That your lordship may know. I have given in that your lordship may.
But these lands are not there, they have given up these lands in the current.
As per the NGT order, as per the undertaking given before.
Sir, I will
the-
pass my orders. If you are agreed, please.
We have-
take on.
ಅಲ್ಲ,
we have done-
facts
I've heard both of you.
facts ತಪ್ಪಾಗೋದು ಬೇಡ ಅಂತ.
Sir, it may be erroneous there also. I don't know.
Facts sir,
Who knows?
correct ಬಂದ್ಬಿಡ್ಲಿ.
ಬುದ್ಧಿ ಇರಲ್ಲ ಎಲ್ಲಾರ್ಗುನು.
ಅಲ್ಲ, just one submission ಅಲ್ಲ. ನೋಡಿ, this ಕರೆಕ್ಟ್ ಬರಲ್ಲ ಅಂತ ನಮ್ ಕಡೆ ತಪ್ಪಾಗೋದು ಬೇಡ ಅಂತ. ಯಾಕಂದ್ರೆ ಈ ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ ತಗೊಂಡಿಲ್ಲ, ಅವ್ರು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವ್ರ
Sanction ಇಲ್ಲ ಅಂತ ಹೇಳಿದಿನಲ್ಲ.
ದೇರ್ ಓನ್ ಡಾಕ್ಯುಮೆಂಟ್. ತೋರ್ಸಕ್ ಹೇಳಿ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ, ತೋರ್ಸಕ್ ಹೇಳಿ ಈ ಸರ್ವೆ ನಂಬರ್ಸ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ದಟ್ ಇಸ್ ಆಲ್ ಆಫ್ಟರ್ ಒಬ್ಟೈನಿಂಗ್ ಇನ್ 23 ಕ್ಲಿಯರೆನ್ಸ್ ತಗೊಂಡಿರೋದು. ನೋಟಿಫಿಕೇಶನ್ 2013. These numbers are not at all there in that. That is a
What they say,
misrepresentation. That's why I'm
as
asking.
per the NGT order, after taking all clearances
Let them
and
show
sanctions,
our lands is not
as
there.
per the order, as per,
Show it.
you read the
Show it,
order,
sir.
read the order.
ಅಲ್ಲ ನಮ್ಮ ಲ್ಯಾಂಡ್ಗಳು ಅದ್ರಲ್ಲಿ ಇದರಲ್ಲಿ
ಇಲ್ಲ,
ತೋರಿಸ್ಬೇಕು.
ಬಿಟ್ಬಿಡಿ.
The order ಅದು.
ಕಾಮನ್ ಆಗಿ
After taking all sanctions, we will execute this scheme. We are
ಇವಾಗ
executing this scheme after
ಇವಾಗ
everything.
ತೋರಿಸ್ಲಿ.
They have put this.
Annexure R6
R6 ನಲ್ಲಿ
ಇಲ್ಲ, ಈಗ ಲ್ಯಾಂಡ್ಸ್ ಯಾವ್ದಿಲ್ಲ, ಎಲ್ಲ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಲ್ಯಾಂಡ್ಸ್. R6 ತಗೊಳ್ಳಿ
R6
ಸ್ವಾಮಿ.
ನಲ್ಲಿ our lands is not there.
Not there.
Okay, sanction under section.
Environmental clearance.
ಅಲ್ಲ, under this act.
ಅದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
4 ನಲ್ಲಿ sanction, scheme sanction.
ಏನ್ ಅಂತ ಹೇಳಿ?
ಇದರಲ್ಲಿ ಇದ್ರ ಪ್ರಕಾರ
Section 5 of Lord, the environment.
notification dated 49/2000. ಅವರ sketch ಹಾಕಿ ಟೇಬಲ್ ಹಾಕಿದ್ರೆ ಇದು ನಮ್ಮ ಲ್ಯಾಂಡ್ಸ್ ಇಲ್ಲ.
ಯಾರ ಲ್ಯಾಂಡ್ ಇಲ್ಲ.
Land ಇಲ್ಲ.
Lord, ಅದಕ್ಕೆ ಅವ್ರು NGT ಹೋಗ್ಬೇಕು, ಇಲ್ಲಿ ಬಂದೆ. ಎನ್ವೈರನ್ಮೆಂಟಲ್ ಇಶ್ಯೂ ಇತ್ತು ಸಂಬಂಧಪಟ್ಟ.
ಹೋಗಿ ಬಂದಿದ್ದಾರೆ ಅಲ್ಲಿ ಆಗ್ಲೇ.
ಅಲ್ಲೆಲ್ಲ ಹೋಗಿ ಅಲ್ಲೆಲ್ಲ.
ಎಲ್ಲ ನೀವ್ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಎಲ್ಲ ತಗೊಂಡಿದೀವಿ ಅಂತ, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ
If
ಇರೋದು.
there is any interim order,
Accord-
it could be one of the
Along with the
reasons for-
statement, additional statement of objection, I have filled all the clearances.
Kindly show it, sir. Let them show it.
ಯಾವ-
ತೋರ್ಸಿ,
ತೋರಿಸಿ ಸರ್.
ತೋರ್ಸಿ ಸರ್, ತೋರ್ಸಿ. ಅನಕ್ಷರ R6 ತಗೊಳ್ಳಿ ಸರ್. ನಾವ್ ಹೇಳ್ತಾರಲ್ಲ, ತೋರ್ಸಿ ಸ್ವಾಮಿ, ಸರ್ವೆ ನಂಬರ್ಸ್ ಇಲ್ಲ.
ಟೇಬಲ್ ಹಾಕಿದ್ರೆ ಲ್ಯಾಂಡ್ ಇಲ್ಲ.
ಯಾರ ಲ್ಯಾಂಡ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Otherwise it will be omnibus argument. My point is, unless my lord our lands are, that I think would be the, our endeavor is, let the facts ಬಗ್ಗೆ correct ಇರೋಣ ಅಂತ ಅಷ್ಟೇ. Not my lord.
Misrepresentation made to the court.
Ultimately, my lord, your lordship judgment, we can't say anything, but factual issues wrong up. That's all my lord we are at.
The learned counsel for all the parties, including the applicant, submitted that in view of the order passed today by the tribunal clarifying the order passed on 16/8/2016, undertaking made by the respondent 3 to 5, that they would obtain all the required statutory clearances from the authorities in accordance with law before proceeding with the developmental work, nothing further.
2013 is the principal preliminary notification. Have you taken on that date?
Annexure R6.
ತಗೊಳ್ಳಿ
ತೆಗೀರಿ.
sir.
Annexure R6 ತಗೊಳ್ಳಿ.
ತಗೊಳ್ಳಿ, ತೋರ್ಸಿ.
all the documents are filed along with that statement of objection.
Correct, sir. ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, sir.
Annexure R6 is dated 3/6/2023, my lord.
Lord, since there were interim orders, ಇದು WP number 433444250 of 2015. Please copy.
R6.
Please copy.
Now, notes of submission, that is our grievance, sir.
In fact, our grievance is that it is taken on 3/6/2023, my lord.
And there is a appeal, stay is granted by the divisional bench. So far, all these lands are concerned.
My lords,
That
environmental
stayed by
clearance is to
divisional
be,
bench,
my
sir.
lord, taken, Lord, when the land is to be, my lord, used for construction.
As of now, it has been taken or not?
No.
Taken.
It has been taken.
No,
It has
As of
been
now.
taken.
Yes,
No.
yes, you know.
That is a
Lord,
specific
may kindly annexure R6 environmental clearance certificate.
Our lands are not taken.
SEIIA.
No.
ತೋರ್ಸು ಅದೆಲ್ಲ.
ಅದನ್ನ that is our returns in office ಅಲ್ಲಿ ಹೇಳಿದ್ವಿ ನಾವು.
ನಾವು
ಅದಕ್ಕೇನು answer
affidavit
ಮಾಡಿಲ್ಲ ಅವ್ರು.
affidavit ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ.
ನಮ್ಮಲ್ಲಿ statement of objection ಹಾಕಿದ್ದೀವಿ.
ಕೋಡ್ ಆಫೀಸರ್ ನಮ್ಮಲ್ಲಿ ತೆಗೆದು.
4334442 43350 of 2014. 2015.
43342, first file.
43344.
23.7.
It is filed on 26/6/2023. Statement of objection.
Yes.
ಅವರು ರಿಪ್ಲೈ ಏನೇನೋ ಮಾಡಿಲ್ಲ ನಮ್ಮ ಆಫೀಸ್ ನೋಟ್ಸ್ಗೆ.
That is one of the contents you are taken. I have given a citation for that. There is no specific denial by statutory authority.
In the annexure R6 ಅಲ್ಲಿ
ತೋರಿಸಿ.
last, there shall be no development in the area of 56 acres 33 guntas demarcated as eco-sensitive zone. ಅಷ್ಟು ಬಿಟ್ಟು ಮಿಕ್ಕಿದ್ರಲ್ಲಿ we have been permitted to develop.
ನೀವು R6 ನಲ್ಲಿ ಹೇಳಿದ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದೀರಿ 3/6/2023 ಅಂತ. There is an annexure giving the details of survey number by the extent of land. In that our lands are not there.
ಅವ್ರಿಗೆ ತೋರಿಸಿ ಅದು ಯಾವ್ದಂದ್ರೆ ಅವ್ರ ತೋರಿಸ್ತಾರೆ ಹೇಳಿದ್ರು.
As there was an interim order, ಅದನ್ನ ಸ್ವಲ್ಪ explain ಮಾಡಿರ್ಬೇಕು.
Sir, you make your submission, sir, here.
All the survey numbers are except there was an interim order with respect to that lands. I think the clearances are not given as on that date, since there was an interim order.
ಆಯ್ತು, ಆಮೇಲೆ ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದೀವಿ.
ತೋರ್ಸಿ.
26/6/23.
ತಗೊಂಡಿಲ್ಲ.
We have applied. ಅದು ಮಾಡಿದ್ರೆ
This is how the way I missed it. That's why you are shouting.
Modification order ಆಯ್ತಲ್ಲ, ಆದ್ಮೇಲೆ we have applied.
Environmental clearances.
ತಗೊಂಡಿಲ್ಲ.
Applied ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ.
ಇವಾಗ ಹೇಳ್ತಾರೆ.
As there was an
Environmental
interim
clearance.
ಹೌದು.
modification order ಆದ್ಮೇಲೆ ಆ ಪ್ರಯತ್ನ ನಾವು ಮಾಡಿದ್ದೇವೆ.
Applied ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಇವರು ಅವ್ರು ಹೇಳಿದ್ರು.
Only after getting the clearance only we will execute. Otherwise we will not execute.
ಇವಾಗ ಯಾವ ಲ್ಯಾಂಡಿಗೆ ಕ್ಲಿಯರೆನ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ?
ಇಲ್ಲ, ಈಗ ರಿಟ್ಪಿಷನ್ ಇರೋದು ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ. ಯಾವ್ದು ಇಲ್ಲ.
All the see, those cases where an interim order was modified with respect to in respect of those cases, we have sought for clearances.
The first time they are making such a submission. Earlier they made a statement, they obtained all the clearances. That's why.
Others, in all other lands we have taken. We have taken.
ಯಾವ್ದ್ರಲ್ಲೂ ಎನ್ವಿರಾನ್ಮೆಂಟಲ್ ಕ್ಲಿಯರೆನ್ಸ್?
ಎಲ್ಲದರಲ್ಲೂ ಇದೆ. ಯಾವ್ದ್ರಲ್ಲಿ
ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
annexure R6 page 16 numbers ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸುಮ್ಮನೆ ಏನೋ ಅವ್ರು ಹೇಳಿದ್ರು.
All survey numbers. Your lords may kindly take page.
They are not taken.
Page 48.
And they are not delayed also in our written synopsis. ಸುಮ್ಮನೆ ಹೇಳ್ತಾನೆ ಇದ್ರು. ಈ ಕೇಸಸ್ ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ. ದಟ್ ಇಸ್ ಸ್ಪೆಸಿಫಿಕ್ ಗವರ್ಮೆಂಟ್ ಮೇಡ್ ಇನ್ ಅವರ್ ರಿಟರ್ನ್ ಸಿನಾಪ್ಸಿಸ್. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಮೆಟ್ ಆಲ್ಸೋ.
See, if we apply and develop the land, if they apply for conversion, the clearances
Let them quash
and
it, my lord, then they can
develop
cover
the land,
activation.
irrespective, in spite of interim order, it amounts to contempt. That is the
Okay,
reason.
ಸದ್ಯಕ್ಕೆ environmental clearances ತಗೊಂಡಿಲ್ಲ.
We have applied. We have applied so far as the lands pertaining to which interim order was there.
ಅಲ್ಲ ಎಲ್ಲಾ ಕೇಸಸ್
All the cases ನಾವು ಬೇರೆ ಕೇಸ್ಗಳೆಲ್ಲ ತಗೊಂಡಿದ್ದೀವಿ, I have given.
ಸರ್ ಕೇಳಿದಕ್ಕೆ ಉತ್ತರ ಕೊಡಿ. ಈ ಕೇಸಸ್ ಅಲ್ಲಿ ಯಾವ್ದಕ್ಕೂ ಎನ್ವೈರನ್ಮೆಂಟಲ್ ಕ್ಲಿಯರೆನ್ಸಸ್ ತಗೊಂಡಿಲ್ಲ.
ಈಗ ಯಾವ್ದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಆ ಕೇಸ್ಗಳಲ್ಲಿ ತಗೊಂಡ್ರಿ.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅಲ್ಲ.
What else it is? Then ಏನು ಸುತ್ತಾಕಿ direct ಆಗಿ
ಮೊನ್ನೆ ತಾನೇ ಮಾಡಿಫಿಕೇಶನ್ ಆಯ್ತು, ಅವಾಗ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ.
ಸರಿ, ಇನ್ನ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ ತಾನೇ.
ಇನ್ನ ಬಂದಿಲ್ಲ.
ಆಕ್ಚುಲಿ ಹೇಳಿ ನಾನು ಬರೀತೀನಿ, ನನ್ನ ಜಜ್ಮೆಂಟ್ ನನಗೆ ಗೊತ್ತು ಏನ್ ಬರೀಬೇಕಂತ.
ಸರಿ,
ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಮಿಸ್ಲೀಡ್ ಮಾಡಬೇಡಿ ಅಷ್ಟೇ.
ದಟ್ಸ್ ಆಲ್.
ಯಾವ್ದ್ರಲ್ಲೂ ಎನ್ವೈರನ್ಮೆಂಟಲ್ ಕ್ಲಿಯರೆನ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ. ಆಯ್ತು, ಏನ್ ಬಂತು? ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ಗಿಂತ ಮುಂಚೆ ಒಂದು ಸೇರಿಸ್ಕೊಳ್ಳಿ ಒಂದು ಸೆಂಟೆನ್ಸ್.
So we will undertake
In
after
respect
only
of,
after getting
the necessary environmental clearance required from the Ministry of Environment, Forest and Climate Change. Full stop. Full stop. Comma. It is submitted by the petitioners that no necessary clearance has been taken by KHB in respect of all the lands which are the subject matter of the writ petition.
And the notification also stayed by divisional bench in a PL, my lord. That subsequent notification, that stayed by divisional bench, where they are a party for that.
Again, subsequent notification.
Subsequent ಅಲ್ಲಿ PL ಹಾಕಿದ್ದಾರೆ. 2012 ಮಾಡಿ 2020 ನಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿಫೈ ಮಾಡಿ 10 kilometers ಮಾಡಿರೋದನ್ನ they stayed by divisional bench. This on court, they are housing with a party for that. That's I produce that.
ನಿಮಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ತೋರಿಸಿದ್ವಿ ಸ್ವಾಮಿ. ಏನಂದ್ರೆ that order has been clarified.
It has been stayed by Supreme Court.
The interim order passed in the PIL which is pending here, is not relevant for this reason. Subsequently, the government has issued notifications and that notification has been clarified by the apex court. That decision was also brought to your lordship's notice, my lord. I was able to convince your lordship that the
That's why we want
interim
to
order
argue
passed is conditional one here. It is only prospective. The interim order passed in the PIL is only prospective. And again, my lord, that subsequent notification has been clarified. Lord, this is what we had submitted. Now again, my lord, they are raising that.
No.
ಏನ್ ಮಾಡ್ತಾರೆ? Sir, I heard you on that, sir.
That has been stayed.
That has been stayed. That has been stayed by
Stayed.
Yes, sir.
For 1 kilometer, it should have been in 2013, up to 2020.
Retrospectively, it can't be.
It is not.
PIL is the interim order of PIL.
So, our endeavor before this court was to say that at the time of acquisition, what was prevailing was criteria of 2011, it instead 10 kilometers.
10 kilometers.
All the lands are covered in that
Grounds
court.
there, no? There are all reports and they are ground.
Here, this court, where in what case of this? So you cannot make use of 2020 notification to say you are acquired in 2013 and it should be approved.
And my lord, all of us.
Housing board is a party for that.
Okay. ಏನ್ ಅಂತ ಹೇಳಿ?
My lord, insofar as the PIL is concerned, my lord, may I just make one small submission, my lords? In the PIL, my lords, the relief that was sought was that until the notification is finalized by the ministry, there shall be no development. That was the interim order. Thereafter, the final note, the ministry has actually notified in the year 2020. So until then is when the interim order operates. So there is not a blanket ban that even after for either passing the notification under the ECZ or for stopping construction after such notification. So the interim order currently, my lord, will not come in the way.
Okay. Yes, ಏನ್ ಅಂತ ಹೇಳಿ?
And the second submission, my lord, on the Environmental Protection Act, the contentions that are being urged, my lord, is that this honorable they cannot urge these grounds before this honorable court because there is a specific statutory bar under section 14 of the NGT Act, because the violation that is alleged is the violation of the Environmental Protection Act. So under Schedule 1, read with section 14 of the NGT Act, my lord, they cannot urge these contentions before this honorable court.
Okay. ಏನ್ ಅಂತ ಹೇಳಿ? I can go with the digression, I suppose. Yes,
That's why I requested half an hour time to explain this in
it's all right.
orally, my lord. ತಾವು ಕೊಡ್ಲಿಲ್ಲ ನಮ್ಗೆ, ಅದೇ ಬೇಜಾರು.
ಇದು previous para.
ಏನಿದೆ?
ಗೊತ್ತಾಯ್ತಲ್ಲ ಅದು. No necessary clearance has been taken by KHB from in respect to the lands from so and so bantala. So and so. Full stop. Next para. Allah continue ಮಾಡಿ. Full stop. Per contra, the learned senior counsels for KHB upon instruction submits that they had made the necessary application in respect of all the lands concerned which are sought to be acquired, and permissions have been obtained
With respect to
in
entry
respect of the lands other than the lands which are the subject matter of the writ petition as full stop. This is because there were interim orders in the present writ petition. This is because there were interim orders in the present writ petition. Full stop.
It's the first time now they make
It is submitted that after disposal of the it is submitted that if it is submitted that layout would be formed only upon obtaining the necessary permissions from the concerned ministry and not otherwise. Full stop. Next para. From the aforementioned submissions of the petitioners as well as respondents, it becomes clear that some of the lands, it becomes clear that the respondents can form a layout only after obtaining the necessary clearance from the Ministry of Environment, Forest and Climate Change. As the property is located near Bannerghatta National Park. Full stop. Further, some of the lands concerned are agricultural in nature, while some other lands have been converted for non-agricultural, residential / industrial purposes. Full stop. Next para. With regard to non-agricultural, residential / with regard to lands which have been converted for residential or industrial purposes, it is seen that the Karnataka Housing Board has left similarly situated lands. It is seen from the documents produced. That Karnataka Housing Board has left out similarly situated lands from acquisition, except those areas that are required for formation of roads as per the comprehensive development plan. Full stop. Admittedly, the land is sought to be acquired for formation of a residential layout by Karnataka Housing Board. Full stop. If the land is already converted for residential or industrial purposes, it may not be under the given peculiar facts and circumstances of the case. This court is of the opinion it would not be appropriate for the respondents to acquire the same. Except the area that is required for formation of the road as per the comprehensive development plan in respect of the area concerned. Full stop. Next para. In respect of agricultural lands, the said lands are sought to be acquired for formation of a layout, and the same is situated in between some of the lands which have already been converted. Full stop. Further, the Karnataka Housing Board has obtained the necessary clearances from Ministry of Environment, Forest and Climate Change in respect of other lands required to form the layout, except the present lands concerned. And in respect of the present lands, the same has not been obtained as there were interim orders passed in the instant writ petition. Full stop. Taking into consideration the fact that necessary permissions have been obtained to form a layout in adjacent lands, and also some of the present lands itself have been converted for residential and industrial purposes. The argument of the petitioners that the agricultural lands have to be left out from acquisition on the ground that the area falls under eco-sensitive zone, while some of the petitioners themselves have the same their own lands converted for residential as well as commercial purposes, may not is definitely not persuasive. Is definitely not persuasive. Persuasive. Full stop. However, it is needless to state that the respondents shall take steps to develop the lands concerned only after obtaining the necessary permissions from Ministry of Environment, Forest and Climate Change. Full stop. Next para. In respect of non-considering the objections raised by the petitioners after preliminary notification by the KHP, this court of the KHP, it is seen that in case of agricultural lands, the petitioners do not have any valid ground to object to the acquisition being initiated by the respondents. Full stop. Under the said circumstances, given the under the said circumstances, this court is of the opinion that it may not be a good ground to remand the matter back for fresh consideration by the land acquisition officer to consider the objections raised by the petitioners. Also taking note of the fact that formation of a layout in a larger area has remained incompleted, though the final notification has been passed way back in the year 2015 because of the interim orders passed in these writ petitions. Because of these writ petitions, interim orders passed because of these writ petitions. Full stop. The petitioners have failed to make out a valid ground as to why the agricultural lands of the petitioners have to be left out from acquisition in the instant case. Full stop. Hence the following order. The writ petitions are allowed in part. The lands which have been converted, the lands of the petitioners which have been converted for residential / commercial purposes, sentence. The writ petition is hereby allowed in part. The preliminary and final notification in respect of
terms of Nadubidi Ramana's case,
in respect of the lands which have been converted for residential / industrial purposes, which are the subject matter of the writ petition. Sorry. Petition is allowed in part, are allowed in part. Lands which are the subject matter of the writ petition, insofar as it relates to lands which are the subject matter of the writ petition, which have been converted for residential / industrial purposes prior to passing of the writ petition. Huh?
Right, acquisition.
Prior to preliminary notification itself.
Prior to the.
Yeah, that's what I said. Yan Madhali sentence. First in the Ode. The preliminary and final notification dated so and so, bearing number so and so, white so and so. Preliminary notification bearing number so and so, comma, final notification bearing number so and so, are hereby set aside, passed by so and so, are hereby set aside insofar as it relates to the lands which are converted for industrial / residential purposes prior to passing of the preliminary notification. Full stop. Which are subject to
Blood.
I don't know why it went wrong. ಹೇಳಿ ಅದು ಮತ್ತೊಮ್ಮೆ ಓದಿ. Insofar as it relate to the lands which are the subject matters of the writ petition, subject matter of the writ petitions. Sentencing ಶುರುವಾಯ್ತು. Confuse ಆಗಿಲ್ಲ ತಾನೆ? Insofar as it relates to the lands which are the subject matter of the writ petition, ಆಮೇಲೆ ಓಕೆ ಈ ರೀತಿ ಬರ್ಕೊಳ್ಳಿ ಅಲ್ಲ satisfactorily worded. ಇದು preliminary and final notification quashed insofar as it relates to the lands which are converted for residential and residential purposes prior to passing of the preliminary notification. Okay. Next, however, subject to the petitioners paying the necessary betterment taxes, charges. Full stop. However, it is clarified that quashment of the notification does not pertains to the lands which are required for formation of the road as per the comprehensive development plan applicable for the area of the land consent.
And also the roads which are absolutely required in formation of layout.
Comprehensive development plan, that's sir. I'm not saying anything else.
Connecting road. Connecting
And are required for connecting the layout being formed by the
housing board.
Karnataka Housing Board. Full stop. Next, the writ petitions insofar as it relates to agricultural lands are concerned stands dismissed. Full stop. Next, however, it is clarified that respondents shall. It's okay, sir. Ishta ನಾನು ಬರಿತಾ ಇರೋದು. However, it is clarified that respondents shall form a layout, shall carry out the developmental work only after obtaining the necessary clearance from the Ministry of Environment, Forest and Climate Change in respect of the land's consent and not otherwise. Next, if a request is made by any of the land losers, for grant of compensation in terms of developed land in lieu of monetary compensation as per the policy of the state, the same shall be considered favorably by the respondents. Full stop. In WP number ಅಲ್ಲೇ ಬೇಕು ಅಂತ ಕೇಳಿದ್ಯಾರ್ರಿ?
Lord, so far as the converted lands, some of the petitioners have come forward and have said no objection for acquiring for formation of road if it is required, and with respect to other areas, paying betterment charges.
ಹೇಳಿದಿನಲ್ಲ ಸರ್ 23.1 ಅಲ್ಲಿ WP number 15/8/34/2016. Yeah, as the petitioner is said to have constructed a house and is agreeable for giving up his land in lieu of compensation by way of
Land sharing
developed
policy.
land. Huh?
Land sharing
Developed land. Developed land. By granting him the required developed land in his own land which is sought to be acquired, the same shall be considered favorably by the respondents. Okay. Next, in respect of WP number 42394 of 2015, 23.6. Respondents, the undertaking of the respondents that the land will not be acquired the land will not be acquired, excluding the land that is required for formation of the road, is recorded and ordered accordingly.
Provided they pay the betterment.
That goes without saying. The
Specific.
petitioner shall be liable to pay the necessary betterment charges. Yes.
36.5 ನಲ್ಲಿ land is edge ಅಲ್ಲಿ ಇದೆ ಏನೋ ಬೇಕಾಗಿಲ್ಲ ಅಂತ
This order will not come in the way of petitioners making fresh representation to respondents for considerations, for fresh consideration, and the respondents are always at liberty to consider the same in accordance with law. Yes.
One submission.
ಇದು 23.5.
Next, in respect of the lands that are acquired for the purposes of roads, it is needless to say that the respondents are liable to pay the necessary compensation either by monetarily or by way of developed land.
Lord, set aside ಅಂತ ತಾವು ಹೇಳಿದಿರಿ. In terms of this disposed of ಅಂತ.
Sir, I passed my orders.
23.5 edge ನಲ್ಲಿ ಇದೆ ಅದರಲ್ಲಿ ರೋಡ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ. If you make a representative, there should be.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
One request in my case, my lord, that is 11, my lord, 11, my lord. Kindly see my lord, my submission again, my lord. Page 5, my lord, para 15, I have made it clear. It does not come, my lord, does not touch the road at all. That's not submission.
Yes, I made my.
In that event, I will make a representation.
ಮಾಡಿ ಸರ್, ಅದಕ್ಕೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ. Yes.
Senior counsel. Environmental clearance, my lord, where required. Lordships have said that and it has to be implemented after taking environmental clearance.
ಆಯ್ತು, environmental clearance where required ಅಂತ.
Where
Yes,
required.
Environmental clearance ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, where required ಅಂತ ಹೇಳ್ಬಿಡಿ. Yes.
Grateful.
My lord, in 23.14, my lords, there is one small submission.
What were you doing so far, I say? What were you doing so far? I pass my orders, you do whatever you want. ಏನ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು? I'll dismiss it for not carrying out the necessary abatement. Let it stand abated. Submit haki immediate agi. If IA is already allowed. What were you doing so far? The incompetence in the entire proceedings gets derailed. Do what is required. Yes, disposed of, sir.
Partly allowed.
Partly allowed.
Partly allowed. If I have caused some incurrence.
No, sir.
My lord, same submission on my behalf also.
ನೀವು ಗುರುಗಳಿದ್ದಂಗೆ ಸರ್, ನಿಮ್ಮಂತ ಸೀನಿಯರ್ಸ್ ಇಂದಾನೆ ನಾವು ಪಾಠ ಕಲಿಯೋದು. We all learn, sir. ಒಳ್ಳೆ ಚೆನ್ನಾಗಿ ಹೇಳ್ತೀರಲ್ಲ.
Same submission from my side also.
No, sir.
Several times we took time, my lord, only to see that, my lord, our interests are protected, that's all.
I hope you are all satisfied with the hearing that was given by the court.
23.5 ನಲ್ಲಿ land comes in the edge, it is converted and building.
Sir, I have given you the liberty to make necessary representations.
ಅದೊಂದು ರೆಕಾರ್ಡ್ ಮಾಡಿದೆ 23.5 ನಲ್ಲಿ.
Sir, on facts, sir, I don't want to do it. ಅದಕ್ಕೆ I have given the liberty. See, ಇದು if I had not pushed, no, ಇನ್ನೊಂದು ವರ್ಷ ಇದು ಆಗ್ತಿರ್ಲಿಲ್ಲ ಇದು. I was required to push it, I pushed it ಅಷ್ಟೇ.
Sadhya, ivattaru at least credit part is closed.
ಮುಗೀತು.
We are
Very,
great.
very grateful.
Thank you.
Set aside ಅಂತ ಪದ ಬಂದಿದೆ. ಅದಕ್ಕೆ ಆತಂಕ.
ಲೋಡ್ ಅಂತ ಹೇಳಿದಿನಲ್ಲ.
ಅಲ್ಲ accusations are set aside.
In so far as it relate to converted lands, that's all. Sir, listen, you are a KHB, sir. ನೀವು ಆಫ್ಟರ್ ಆಲ್ ನೀವೇನು ನ್ಯಾಷನಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲಿ ಏನು ಅಕ್ವೈರ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಇವಾಗ ಅದೊಂದು ಪದ ಇನ್ನೆಲ್ಲದಕ್ಕೂ ಬರುತ್ತದು. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿನ ಆದ್ರೆ you are acquiring for housing purposes when they themselves have
ಏನಿಲ್ಲ, in terms of ನಡುಬೀದಿ ರಾಮಣ್ಣ's case.
Anyway, I have done it, sir.
Please.
Yes, next case.
24, Bharat Kumar V.
Yes, I appear for. I appear for.
By virtue of an earlier order, I was directed to file an affidavit, my lords. May I just place this on record, my lords. To indicate, my lords, para number 5 onwards, we have stated that there are two officers which are involved in two districts, my lords. One do Bangalore North Taluku, one do Urban.
Yardri land.
My lords, ultimately, the only question I have to answer, my lords, is to say whether it was a granted land or not. Original record tarastini.
I have directed the authorities concerned to file an affidavit stating, see, there is no dispute that the contesting respondent ge grant agiro dispute alli illa. Okay. Our contention erappa andre the land was granted to them prior to the same being allotted to the contesting respondent.
Please.
Okay. The question that you are required to answer is
Whether there was a grant earlier to the allotment.
yes, yes or no, that's all. Have you answered it?
No, my lords, we have paid para 5, may I just read it for my lords, thing, my lords.
They say, my lord, they need 4 more weeks' time. My lord, we have produced the certified copy.
See, listen, the court does not want to.
No, they have to answer as your lordships of
Ashta,
my lord on 16/12/2024.
I will place the original before my lords.
No, we are not satisfied by that. Last time also the same mischief was done.
The reason is this, my lords.
See, your officers are cahoots, some of them. You initiate a criminal inquiry. No, you initiate a criminal inquiry.
That's the reason we have stated in the affidavit to
No,
say.
now your officers don't want to answer the court query as to whether the land was granted in favor of the petitioner
Please, my lords.
prior to the same land being granted in favor of
Allotted to
contesting
the
respondent
contesting
or not.
respondent, please.
Okay? ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಬೋಗಸ್ ಎಲ್ಲ ತಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಎಸ್ಬಿಟ್ಟು ನೀನ ತೀರ್ಮಾನ ಕೊಡು. ಯು ಟೇಕ್ ಯು
ಅಲ್ಲ, bogus ಅಲ್ಲ.
ಶೆಲ್ಟರ್ ಅಂಡರ್ ದ
Lord, may I make
court seal.
My lord, bogus ಅಲ್ಲ, ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ they
May
have
I
to
make
answer.
one submission?
Not-
Allah, may I make, my lords, one second. Lord, may I
Yes.
make? Lord, I appear for the petitioners in this case, my lord. Sorry, respondents. The petitioners ought to have produced before your lordships their claim. They can't come here and start doing a fishing inquiry, asking us to prove their title, number one. Number one, notwithstanding that lordships were kind enough, indulgent enough to direct the revenue authorities to show their title. Not this deputy commissioner, I think possibly thinks he's above the court, my lords. This is the 10th time lordships are directing, and he's coming up with some cock and bull story, filing an affidavit before your lordships, saying that I will want 4 more weeks. It will take not more than 5 minutes to find out whether there is grant or not.
You are required to, it is your record. You are required to state whether the land was granted to the petitioner or not. That's all you are required to state.
No, I think it is intentionally done in order to deprive the 4th respondent much to be deprived of this land.
Whether it is intentional or not, my lord, that.
No, it is clear, my lord, no, it is very clear.
It's not against
These
you,
revenue
sir.
authorities
No, no,
cannot
it's
act
not against you.
before your lordships,
What he
before the
says
highest
is
court
that,
under Article 226,
he's doing it
227.
intentionally. He's doing it
And
intentionally.
lordship
The
direct.
conduct of DC is
No, my lord, my
The
case
conduct
also-
of the
my
DC,
case
my lords,
is also
requires
that.
criminal
Nobody is
proceedings,
blaming you.
proceedings to be
The
initiated
conduct of
against him.
DC.
No, my learned friend says that DC is doing on the behest of the petitioner. My lord, my allegation is DC is doing on the behest of the mud, not on the behest of the petitioner.
Yes, double HG, what do you say?
My lords, I request 1 week at least, my lords, I'll produce it, my lords. I'll produce it, not an issue.
Release from parted.
My lord,
Call next week.
my lord, your
Post
lordship
mortem
have-
before
Lords,
appropriate.
may I make one request?
Yes, sir.
My lords, may I make one request? My lord, lordships may not release it from parted only for this, only it has reached a penultimate
yes, my
stage.
lord, your
Either way,
order-
my
order-
lordship.
Nawadgi, see, the problem is I'm not sitting every day. See, I don't know when when I'll be sitting single next day.
Lord,
That's
Lord,
the-
Lord, at least may I make one more, at least one request, madboda. May I make only one request?
Both
Lordships
of us
may
are submitting, my lord.
The
we have
Lordships
no
may
problem.
record.
Government also
record
says,
the-
my lords may have it,
WAG that within
my
1
lords.
week
We
they'll
may not be
produce the
releasing it.
record.
I don't want to sit on here.
ಅಲ್ಲ, ತಾವ್ ಯಾವತ್ ಕೂತ್ರು we are
No,
ready to
all of
produce.
you may like me to hear the matter, but I'm not interested.
Since your
Yes,
lordships have already, my lord, we have no problem, my lord. Your lordship may have it, my lord. Whenever next sitting day, my lord, let the government produce it.
nothing. The learned AAG has filed an affidavit of Sri so and so. It is seen the contents of the affidavit are not in terms of the direction issued by this court. Full stop. The learned AAG apologizes for the same and further submits that proper affidavit would be filed by next date of hearing. Full stop. Recording the full stop. Next para. Release from parted, post the matter before appropriate bench. Yes.
Lords, only one request, my lord. One request. Dayvittu that one. Lords may record the statement of the AAG that he'll produce the records within 1 week and fix a date, my lords. Great,
Yes,
my
ma'am.
lord.
See, it
One
may not
date
be-
may be-
see, it may not be appropriate for me to fix a date because the matter is going up before a different judge altogether.
Next week ಅಂತ ಅದ್ರ ತಾವು ದಯವಿಟ್ಟು ಹೇಳಿ ಇಲ್ಲಾಂದ್ರೆ it will not come up.
Call
on the-
next week ಅಂತ ಹೇಳಿದ್ದೀನಿ. Call next week ಅಂತ ಹೇಳಿದ್ದೀನಿ.
Along with the documents, along with the documents.
Yes. Next ಬಂದಿದೆ ಅಲ್ಲ. Yes.
25 adjourn. 26 Harish Kumar MS.
My lord, I appear for the petitioner in this matter. It is a matter where, my lord, I have sought for lease of the land. My lord, it has been rejected on different grounds.
Government.
That too, my lord.
Release from parted. They are not interested. Government, I can't help
My
it.
lord,
Release
my
from
lord, again,
parted.
your lordship has
Matter before
spent
abroad. I can't
lot
help
of
it.
time, my lord.
Harish,
My
I
lord,
can't help you.
My
Yes.
lord, I request, your lordship has spent lot
No,
of
no,
time.
no, carrying forward business.
No,
Yes.
no, it's not that, my lord. Your lordship has understood the crux of the matter and wanted to give the justice to the parties. My
What
lord,
can I
that is
do?
what we required, my lord.
Government is not
engage your lordship,
listening.
my
I
lord.
can't help it. I can't help it. Which one? 27 or release from parted, sir? Let it go before appropriate.
27, my lord. Your lordships have heard it.
Sir, I don't know when I will be sitting next. Sir,
Any Friday, any Friday. your
Sir,
lordship-
I don't know when I will be sitting next. That's my problem. For 2 months, it will not proceed further. Sir, I'm releasing all the matters.
No, because my lord, your lordships heard this matter for some time. And my lord, only thing is, my lord, we have to justify whether, my lord, the final notification has been
Sir,
issued.
but I don't think it's appropriate.
My lord, your
I
lordship
don't think it's
kindly-
appropriate. Release from parted, sir.
No, my lord, your lorship kindly, my lord.
ಶುಕ್ರವಾರ ಕೆಲಸ
ಹೌದು sir. ಅವತ್ತು ಕೂತ್ಕೊಂಡಿದ್ದೀವಿ sir. My lord, all of them are.
Sir,
all of them
I'm
are-
releasing everything from parted.
No.
I don't want to keep anything.
No.
Not only in your case, sir, even previous cases.
My lord, your lordship may kindly, my lord, so far as this case is concerned. My lord, your lordship heard it for some time, so far as the other matter which is.
Sir, Ajay ಇದ್ದಿದ್ರೆ ಬಹುಶಃ I would have dictated it that day
ಅಲ್ಲ,
itself.
ಇದೂನು ಅಷ್ಟೇ ಜಾಸ್ತಿ ಹೊತ್ತೆ ಅಂತ ಅವಳು ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಮೋರ್
ಅಲ್ಲ ಇವಾಗ ಫಿನಿಶ್ ಮಾಡಿದ್ರೆ ಕೇಳ್ತೀನಿ. ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿದ್ರೆ ಕೇಳ್ತೀನಿ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್ ವಿ ಆರ್ ರೆಡಿ ಮೈ ಲಾರ್ಡ್ ವಿ ಆರ್
Yes, if both of you argue the matter today, I will hear.
yes my lord we will argue my lord we will not take any time
Let it go before appropriate.
we are not taking any time my lord we my lord I prepared synopsis and my lord in the form of points
ಕೊಡಿ ಹಂಗಾರೆ both sides are ready. ಯಾರಾದ್ರೂ ಬರ್ಬೇಕಾ? ಎಲ್ಲ ಇದಾರ ನೋಡಿ.
ಇದೆ ಕೊಡೋದು
Jay Kumar Patil. Sudan Rao. Ashok Naik.
ಕೊಡಿ
Okay, 2:30 I will take it up.
yes
2:30.
yes
Possible.
28 adjourn. 29 Harish HV.
It's only I'm seeking for remand of the matter, lordships. Is there only 2 sentences, my lord, we are already arguments are concluded. Survey number 46, my lord. I have also produced the records. It's allotted by way of partition. Partition is not challenged by anybody. Even in the objections, my lord, they've said they accept the partition. Secondly, my lord, out of total extent, my lord, 6 acres 17 guntas. My lord, minus 15 guntas of Karab. 6 acres 2 guntas have been allotted in favor of the parties. RTC extracts are there. Now, my lord, I filed an application to demarcate my land and podi my land. For that, my lord, answer is, my lord, kindly see, my lord, that page number 16. Only that, my lord, I'll leave it to this honorable court. Page number 16, lordships.
ಥರ್ಡ್ ಲೈನ್ ನಿಂದ ಗ್ರಾಮದ ಸರ್ವೆ 46 ಅಲ್ಲಿ ಹಕ್ಕು ದಾಖಲೆ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ಅನುಭವದ ವಿಸ್ತೀರ್ಣಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿರುವುದರಿಂದ ಹಾಗೂ ವ್ಯತ್ಯಾಸದ ಪ್ರದೇಶದಲ್ಲಿ ವಾಸದ ಮನೆ ಸೋನ್ಸೋ ಇರುವುದರಿಂದ ಎಲ್ಲಾ ಖಾತೆದಾರರ ಹಿತಾಸಕ್ತಿಯ ಪರಿಗಣಿಸಿ ಈ ಪ್ರಕರಣ ಸಿವಿಲ್ ಸ್ವರೂಪ ಎಂದು ಪರಿಗಣಿಸಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಸೋನ್ಸೋ. What I said is, they've already measured the land at page 14. They need to measure the land as per the rights and as per RTC extract, not as per the possession of the parties. That's all the contention, my lord. The order needs to be set aside and a matter requires remand, and let them survey the land as per the right at the partition and RTC extract, which has a presumptive value. If at all anybody is aggrieved thereafter, my lord, either possession or whatever it is, my lord, let them go to civil court. And your lordship's judgment also, lordship, is very clear. My lord, Podi needs to be done, my lord. They cannot, 46 survey number, each brothers, my lord, have been partitioned. My lord, this is a reported decision of your lordship's lordship. This was in respect to a grant, but the wordings there, lordship.
This pertains to grant, I said.
Correct, lordship. Para 12, page 12, 6 and 7. My lord, they need to do Podi, my lord. They can't send it to the civil court for doing Podi. It's a job of the survey officer. That's why they are appointed. Para 7, my lord. 6, 7. They need to do Podi and Durasti, my lord. As per the right, not as per portion. Portion they may show. That's all my contention, my lord. They can't absolve the liability of postponing the Podi and leave it to the civil court. It's a domain of the survey authorities. 82 partition is accepted, my lord, by everybody. Page 14 ನಲ್ಲಿ ಆಸ್ತಿಗಳನ್ನು 14-182 ಪಂಚಾಯತ್ ವಿಭಾಗ ಪತ್ರದ ಮುಖಾಂತರ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದು ವಿಭಾಗ ಪತ್ರದ ಅನ್ವಯ ಸೋನ್ಸೋ ಅವ್ರಿಗೆ ಬಂದಿರುತ್ತೆ. MR ಆ ತರ ಆಗಿದೆ. RTC extract, it is shown to that extent only.
Request for a pass on my lord, senior is held up in other court.
That's possible. 230.
Lords, in 30 I appear. My lord, these were 3 writs petitions where the refund was being sought.
In this case, the assessee has filed, the petitioner has filed one document, not an A1A, stating he has produced the letter dated 30th October 2015 before the assessing authority. Manual return was filed and reassessment order was taken up in the said assessment year for financial year 2010-11.
Arguments were heard completely.
Completely arguments were heard. May I say one sentence, my lord?
This document is specifically disputed, my lord. The assessing authority in the reassessment order, it says that no return has been filed. So I have to file additional synopsis stating that it has not been filed.
Kindly see, my lord, these are 4 years. 10, 11, 12, 13, 13, 14 are before, my lords. 11, 12.
Now he wants to...
Kindly see, my lord, they can keep on filing. But please see the bona fide of these people. They file a synopsis. Kindly allow me to complete. Kindly allow me to complete. They file a synopsis before, my lords. Kindly see in the synopsis, they state I have not filed a return for in between 11, 12 year. Factual inaccuracy. Kindly see the bona fide of the government council. A sovereign is behaving like this. My lord should stop this. It has to stop somewhere. They are sitting on my money on merits. On merits. Kindly don't interrupt me. Kindly don't interrupt me. May I complete it? May I complete it? My lord, kindly see, there are 4 assessment years. The issue in this is royalty. Whatever on merits they are raising, they are before the division bench because up to tribunal I have succeeded. Based on a Supreme Court decision where the review has been dismissed also. Now, for these 4 years, they ask me to file a return. I file return on the same day for 4 years. They choose to process the in between 11-12 year. And that has reached through the tribunal like finality, in the sense a finality to the as on today, because they refunded the money. And in the other 3 years, we have been quarreling before my lords for the last 3 or 4 months. And when they file a synopsis is filed by the council, not under instruction by somebody. If an error, not I am stopping myself from saying a lie, a blatant lie.
I object, my lord, for this
Please
type
let me
of allegations. Let him file the affidavit, my lord.
Why? It is, you read your synopsis. It says on the first one that, I didn't file a return on 11-12. I have shown you an acknowledgement for 11-12. What else it is? It is not a lie. If it is not a lie, what else it is? On the very same day, I filed for 4 years, you say it is there. In the 4th year, it is not there. Is it not a lie before the court? And not by the instructing officer behind it. What else can be more worse than this, my lord? And I am being, how many years I have been patient. I have been allowing, my lord said on the last occasion, they want to file something. I did not object. This is going on for last 3 times. I did not object. Synopsis is filed. Paper books are filed. Everything is there. Decide one way or the other. I have no problem. But please decide. They will go on postponing it like this because they are sitting on my money. My lords, if this case is to be considered as a classic, it is an example of why people don't want to pay the government. Once they get this money, they will do anything, any means they want to retain that money. Kindly see from 10-11 to 13-14 is before, my lords. From 14-15 to 18-19, the tribunal has given. Department may have any view. You appointed a tribunal. The tribunal has decided in my favor, following a Supreme Court decision where a review has been dismissed. You want to contest, you contest. But can you deny me these 4 years? And in these 3 years before, my lord, why am I before my lords today? Because 1 year they chose to process, other years they didn't process. After asking for the return themselves, on the same day I filed the return. Now, if they had processed, I would follow the alternate remedy. They would have reached whichever way, whether they get money or I get money. For fault of not having processed themselves, they want to go on arguing before my lords endlessly, saying, I will file this application, that application. Do whatever you like. How is it going to change that I filed a return on the very same day? And you earlier year and the later years, you didn't process it, leaving me with no alternative but to approach this court. And on kindly see, my lord, there is a very vital difference. An affidavit is filed maybe by the officer. Here is something where a synopsis is being filed by an officer of the court to assist the court. And in the very first line on synopsis for 11-12, they say return has not been filed. Can there be a more? Is this the responsibility that I have towards a court, my lord? I didn't want to go there. I refrained myself last 2-3 times. But my lord, where will this end? I leave it to my lords. This is all on record. On the very same day, in between here, I filed 4 returns on the same day. You processed the second one. I went to the tribunal. I got a refund. First and third, 4th year, you didn't process. I could not have gone. I also explained why I could not file a writ earlier. Because there was a division bench of the Karnataka High Court which was against me. That got decided in 21. Your review petition was filed. I waited patiently. Every time this came up, I brought it to your notice, saying, sir, this is pending. I filed a refund return before you. Process it. It is invalid. It is invalid. If I have to go to CBDT, you should have said that. The Honorable Supreme Court says in HH, I have filed a case law compilation. Kindly have it. It is from Karnataka only. It says, kindly have this one, my lord. Only one case, kindly have this compilation 5, which my colleagues in the court will hand over. It says, no way you can retain it. No way. It is violation of Article 265. I don't need to approach CBDT or anything. Moreover, whatever CBDT can do, this Honorable Writ Court can do more effectively. I also pointed out on the last occasion, they are going on arguing you should have approached CBD. CBDT power has power for 6 years. That 6 years was left much before the Supreme Court decided it. How will I go to the CBDT for that?
Your Lordship, I have to fill additional service. Your Lordship, from his own record, my Lord, from his own record, Your Lordship may kindly have 1A, my Lord.
Sanmati, after everything was
Your Lordship,
completed,
I have not even concluded the argument. Your Lordship, even whether royalty is applicable or not, it has not been argued.
That is not the situation
Your
here.
Lordship,
That is a merit case that
there are
has to be
2
argued
points, my
before
Lord, whether
division
it is
bench.
chargeable to tax or not.
Tribunal has
Your Lordship, I
decided
have
it
to
10
argue further,
times.
my Lord. Your Lordship, whatever he is stating, it is one contrary to his records. Your Lordship may kindly have 1A, whatever is said last time, my Lord,
Tribunal has
without any
decided
affidavit.
whether it is royalty or
Your
not
Lordship,
for
he has
5
completed
years.
his argument.
6
I have started
years.
now.
You have not even
I did not interfere when he was arguing the matter.
Your questions have not been admitted by the division bench. For you have filed that appeal with a 461-day delay. Delay condonation is being objected.
Yes, just now he stated that my appeal is not admitted. This is the admission order sheet.
Admission behind my back doesn't matter that the writ
When the
writ
matter is
payment will
pending
be
before
stopped.
the honorable division bench regarding the same issue, when he is stating before this honorable court, this matter is not admitted. Your Lordship, the
refund for
questions
7
of
years
law
you
have
take,
been
this also
framed
you
and matter
take.
is admitted.
My lord, let them take this 3 years also when they win. 7 years they have paid me.
Let this matter be placed before the division bench also, my lord. Because the main matter on merits, whether royalty is applicable or not, that has to be decided.
But
Even
the
otherwise,
tribunal
let
has,
the division
my
bench
lord, the
decide.
tribunal order has no value. Tribunal order has no value. What
Your
Sanmati
Lordship, how
says is
can
the
he
only
rely upon
value.
tribunal's order when matters are pending before division bench, my lord?
Then what? When tribunal refund money for 7 years. Because tribunal is a court. You may have ideas beyond the tribunal that you have to try in the high court. When it is reversed, yes, you take this also along with the 7 years. You have given 7 years refund. You didn't do it with closed eyes. You are the contempt.
Your Lordship, for a moment, kindly have 1A document, my lord. He has said that he has filed this.
What is that you want to file now?
Your additional synopsis have to be filed, my lord. Whether it has been filed or not, have to bring it before this honorable court.
Pleadings or just synopsis? What do you?
Your Lordship, each time at the end of the argument, he is filing some documents, my lord. Have to give reply. In the last
Not
occasion
true.
only, this has been filed.
Not
and in
true.
the reassessment order itself, it has been said that this return of income, it's not filed.
Not true. I had to file that to show that the first line of your objection saying that 11-12 was not filed is a blatant lie.
I'll just finish my submission. Every time I make one submission, he's interfering, my lord.
Nageshwar Rao, you finish your submission and hear the other side.
Yes, my lord. The point is this. I filed my synopsis to which showing that Supreme Court says, my lords, kindly see, this is the second round before my lords. In the first round, this honorable court said, please follow K. Nagesh, decision division bench of this honorable court. Even if it is invalid return, even you could not process, you had difficulty, etc., etc., you can't keep the money, please refund. The division bench, unfortunately, the earlier learned single judge was unfortunately a little kind and considerate to say, consider it in accordance with K. Nagesh. In the order, they say, there is no clear direction from the High Court, therefore we are not giving. Now, after that, my lord heard it at length. I was given an opportunity to file submissions. I filed the submissions along with case law to show that Article 265 does not permit them to retain something which today is not royalty. Not royalty, not according to the appellant, not royalty according to a tribunal set up properly and not for 1 year, for 7 or 8 years, all orders are part of record. Now, once that is so, now 4 years remain. As I said, the first, third and fourth year are before my lords. In this, they said, they gave, please file your return. If royalty it was, Then in the second year, they gave me a 147 reassessment notice. That is the 11-12. All 4 returns on the same day I filed. For the second year, they gave me a notice. We are reassessing what your income is royalty. I took it in the normal statutory appeal route. Succeeded. Got refund. First, third and fourth years are before my lords. They did not do it at that time. I could not approach a writ at that court because from 11 to 21, 23, the Honorable Supreme Court was considering this issue not only for me, for everyone. Once that was done, the tribunal gave me relief. They paid me the money. Can they now say that in the second year, whatever was applicable first and third, fourth year, it is not applicable? Up to 8th year. Okay, I did not quarrel with that also. Well, let's kindly see. When the synopsis I filed, I gave a copy. They come back with another copy. Kindly see their synopsis. First line, 11-12, no return filed. My lord, I filed the same return on the same day for all 4 years. Okay, you still are not satisfied. You think that something else will apply in my case, it is royalty. You are before the division bench, that is on merits. Give me my refund this year. If you succeed in those 7 years, please
We'll
take
do one
that money.
thing. I have heard both the parties at length. Listen, we'll do one thing. I have heard pleadings are completed.
Additional synopsis has to be filed in reply to this, whatever you state filed.
Fine, I'll give you time for that. It's only on arguments you want to file something. I'll pass a judgment after 1 week. I will not pass judgment for 1 week. You file whatever you want. I'll reserve it for orders. I think that takes care of everything.
And my lords, yes, I can make one concession. Whatever he writes, I don't want an opportunity to even rebut it. My lords, what else I can do? Kindly see, I showed a Supreme Court decision where the Supreme Court lamented that the government council should not
Written
take
arguments
such.
itself you file if you want to.
Your Lordship, I will file additional synopsis. Your Lordship, there are 2 issues. Whether he has filed the return in time
Correct,
or not.
Sarmati, I heard you.
Merits ಮೇಲೆ division bench ಅಲ್ಲಿ ಇದೆ ಅದನ್ನ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
ಆಯ್ತು, you file it. You file it. I'll pronounce my judgment only after 1 week, not before that.
Yes.
By considering whatever that you want to file.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತಾನೆ ಇನ್ನೊಂದು ಡೇಟ್ ಹಾಕಿ ಸ್ವಾಮಿ.
No further hearing.
ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ ನಾನು ಇನ್ನೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕು. Let me conclude the argument today itself, not.
Okay, 2:30 I'll hear you then.
Obliged to my lords. My lords, those 2 cases which my learned friend is referring, I have filed it as compilation for.
Hear you.
Yes, no.
See, because I'm not keeping any matters which requires an adjournment. Okay, I'm releasing it from part 8. See, I just wanted to pronounce judgment in this matter simply because I thought I heard completely both of you.
Your Lordship, I have not even comments regarding the merits of the case, my lord. That has to be decided, my lord. And also that this return is not
See, at
filed.
2:30, if it is not possible, I will be forced to release it. Leave it to you. Yes, 2:30, sir.
Obliged to my lords. Obliged to my lords.
If it doesn't happen today, I will be releasing it from part 8. That's
My lord, please don't say that. That will be taken as the as an opportunity to not complete it today and get it released. Believe my words, I am not saying anything against my friend. I know him from the day he comes to the court. Ask him, he will confirm that.
Okay, let's just pass over.
But please, Your Lordship, I appear in this matter. This is that matter where we had challenged the jurisdiction of the adjudicating authority and also the show cause notice that was issued exercising section 74.
I think it will require some more arguments. I think I'll be releasing it from part 8.
My lord, please, my lord, because I've spent time since
the
October.
The problem is I'm sitting in a division bench.
I understand.
I don't know whether I can sit single this roster itself or not. Okay, I'm sitting.
My lord, I'm willing to wait for 2 more months.
Justice, that's the problem.
I understand. I'm willing to wait for 2 more months. I have no difficulty, but substantial time has been invested.
No, it will not look nice because see what has happened. The other side has not even commenced arguments in this matter. I think you will be required to argue quite some time also. So let it go before appropriate bench.
2 points, my lord. 2 points that they have in their file, the counter, it comes out very clearly.
It will take time. That's the
I
only
understand.
reason.
I will
Yes.
not trouble, my lord.
Release
Then, my lord,
from
may I
party.
pray for two things, my lord? The
Yeah.
interim order may be extended. My
Yeah,
lord,
that
there is
will
an
be
interim
done.
order that may be extended. And my lord, if my lord can put a line to prioritize the hearing before the learned judge,
That I
whenever
can't
it
do.
comes up
The
before
first
the
one,
roster
yes,
bench,
it
my
will
lord.
definitely be done.
Because
Yes, release from part head, post the matter before
very
appropriate
well.
bench, interim order if any is extended till next date of hearing.
My
Yes,
lords, we have drafted a rejoinder. If direction may be given us.
you do whatever you
I'm so
want.
blessed.
You do whatever you want.
32,
Yes.
what in person? Ajay, B. Vachan.
Yes, Vachan, if he is ready to complete, I can hear, sir. Otherwise, sorry, I can't.
No, I'm ready. I'll
You have
require 5
finished
minutes.
your
of your time.
arguments, I know.
B. Vachan.
You have finished your arguments. So them, can't help it.
No, I have only one submission to make. When he arrives, if you can grant me 5 minutes to make the submission.
Sir, I heard you completely. It was for their response. They are not coming forward.
But that is their conduct.
Yeah,
It's
see,
not
the
20 years.
problem is I'm constrained because I'm sitting
Understand.
in a division bench. That's the reason. Release from parted.
If
Call
it can be
next
passed
week.
over, if they come in the afternoon, at least it may be taken up.
I pass over. 32 pass over. Let's see.
33, B. Ramesh.
Nice matter, my lord. Maybe list along with other matters on 4th of February.
This is the matter along with WP number so.
The interim order
Number 50634 of 14.
Interim order ಇದೆಯಾ? Interim. ಆಯ್ತು. Interim order if any is extended till next date of hearing.
4-2 ಕೊಟ್ಟಿದ್ದಾರೆ, 4-2. 4-2. 4-2.
4-2 ಅಂತ ಕೊಡ್ಬೇಡಿ, ಲಿಸ್ಟ್ along with so and so ಅಂತ ಹಾಕಿ
List
ಸಾಕು.
along with ಅಷ್ಟೇ. 50634 of 14. 4-2 ಬೇಡ.
So,
ಅಷ್ಟೇ.
see, 29 I was thinking, if we can, just I'm suggesting from the court, if we can remand the matter back to the extent with the direction, let them state, let them do that Podi Durasti in respect of both as per the RTC. I mean, as per your partition deed.
ಅಲ್ಲ
number one.
ಅವ್ರು ಯಾವ ರೀತಿ ಆಸ್ ಪೊಸಿಷನ್ ವೈಸ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಹೇಗಿದ್ದಾರೆ ಹಾಗೆ ಅಳತೆ ಮಾಡಿದ್ರೆ ಬೋತ್ ಸರ್ವೆ ನಂಬರ್ 51/1
I'm going to order as per the partition deed what they are entitled to, and as per partition deed what they would be entitled to, and ಇವತ್ತಿನ ಅನುಭವದ ಪ್ರಕಾರ what they are entitled to, reserving the liberty to the parties to approach the civil court to decide their rights in respect of the property concern. Two aspects will be highlighted. Number one, as per partition deed, what they are entitled to. Number two, as on today, what they are in possession of.
See, partition is already effected, acted upon, they are in possession. ಇದೇನಾಗಿದೆ ಸರ್ವೆ ನಂಬರ್ ಪಿಟಿಷನರ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಸರ್ವೆ ನಂಬರ್ 119 31 ಗುಂಟಾಸ್ ಡಿಫರೆನ್ಸ್ ಇದೆ ಬಟ್ ದೇ ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಆಫ್ 34 ಗುಂಟಾಸ್ ಇನ್ ದಿ ಅದರ್ ಸರ್ವೆ ನಂಬರ್ ಸೇಮ್ ಅಡ್ಜಸ್ಟ್ ಅಂದ್ರೆ ಅದು ಒಂದೇ ತರ ಇದೆ ಪಕ್ಕದಲ್ಲೇ ಹೊಂದ್ಕೊಂಡಂಗಿದೆ. So they are in occupation of 4 guntas more than others.
That I'll observe.
Sir, ಆಮೇಲೆ ತಿರುಗಿ ಲಕ್ಷ್ಮೀ ದೇವಿ ಸೆಕೆಂಡ್ ಒನ್ ಸರ್ವೆ ನಂಬರ್ 46 1 acre 19 ಗುಂಟಾಸು 9 ಗುಂಟಾಸು ಜಾಸ್ತಿ ಇದ್ದಾರೆ. ಆದರೆ 51/1 ಅಲ್ಲಿ 34 ಗುಂಟಾಸ್ ಕಡಿಮೆ ಇದ್ದಾರೆ. ಸೊ ಲೈಕ್ ದಟ್ ಸರ್ವೆ ನಂಬರ್ 46 ಅಲ್ಲಿ 1 acre 21 ಗುಂಟಾಸ್ಗೆ 31 ಗುಂಟಾಸ್ ಹೆಚ್ಚಿಗಿದ್ದಾರೆ. ಯಾರು? ಶಿವರಾಮಯ್ಯ. ಸೊ ಆ 51 ಅಲ್ಲಿ 36 ಗುಂಟಾಸ್ ಕಡಿಮೆ ಇದೆ. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅವರು ಭಾಗ ಅಂದ್ರೆ ನಿಲುವಾಗಿ ರೋಡ್ಗೆ ಬರಬೇಕು ಅಂತ ಹೇಳಿ ಎರಡೂ ಪ್ರಾಪರ್ಟೀಸ್ ಸಮವಾಗಿ ಭಾಗ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅದರಿಂದ ಏನು ತೊಂದರೆ ಇಲ್ಲ.
Page 16.
ಅಲ್ಲ
pertaining to 46 lordships.
No, come to page number 16, Harish.
Yes, lordships.
That exercise has already been done.
No, that if that exercise is done, they need to do it at page 14. Make kindly.
No, one nimsha, you answer me this.
It is done. It is done. Correct.
Page number 16, if you come to
This exercise is done.
RTC ವಿಸ್ತರಣ ಏನಿದೆ, ಅನುಮೋದಂತ ವಿಸ್ತೀರ್ಣ ಎಷ್ಟಿದೆ,
Correct,
ವ್ಯತ್ಯಾಸ
lordship.
ಎಷ್ಟಿದೆ, ಬಂದಿದೆ.
Exactly, my lord. That's what I'm saying. No, my lord, turn to 14, my lord.
Hmm.
They only, my lord.
They
give-
are not accepting our proposal.
Page 14, they're showing, my lord, they don't show as per right and possession both. That's a problem. They only show as per the possession. That is incorrect. That's all, my lord.
See, boundaries prevail over the extent.
If
R
extent-
number, that is the settled law.
And if extent is,
Ah,
if extent is not
they
disputed.
are in occupation of more extent than others.
No, that is incorrect, my lord. Survey number 46, I am only
ಬರೀ
concerned.
he is confined to ಸರ್ವೆ ನಂಬರ್ 40. ಎಲ್ಲರಿಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ. ನಿಮ್ಮೊಬ್ಬರಿಗೆ ಅಲ್ಲ.
I've
ಎಲ್ಲರಿಗೂ
come to
ವ್ಯತ್ಯಾಸ ಇದೆ.
my lord, permit me, my lord, only one.
I'll release from parted, let it go.
My lord,
for the-
my lord, only this, my lord, your lordships heard me right. Only thing what they need to do is 46 ಅಲ್ಲಿ ನಾನು ಎಷ್ಟು ಪರ್ಸನ್ ಅಲ್ಲಿ ಇದೀನಿ ರೈಟ್ ಎಷ್ಟಿದೆ. That's all, my lord. And let-
No, that you go to the civil court. You go to the civil court.
No.
You
exactly-
pursue your remedy in civil court, not before this authority.
One ನಿಮಿಷ sir. Sir, what I'm, my lord, what I'm stating is only this. Survey authorities, my lord, do need to do PODI. My lord, as per the right and as per RTC. My lord, if they're in portion of the property in excess, my lord, even they can show that they're in portion of the property in excess. Then I will go to civil court. That's all, my lord.
ಆ judgment ಕೊಡಿ ನಂದು. ಅದು
I have given it, lordship.
reported judgment ಅದು ಕೊಡಿ ಇಟ್ಕೊಂಡು.
Pass suitable orders, my lord. That's all.
No, I have to argue this matter. Lord, better remedy would be referring the matter to the
Sir,
mediation.
senior says he has to argue the matter, let it go before,
My lord,
uh,
my lord, his argument is only, my lord, I am in excess of the land in other survey numbers. My lord, I'm only concerned with this survey number 46. Pass
correct.
suitable orders, my lord.
See, look at your prayers for a minute.
My lord, my prayer is only that, lordships. They're not done Podi's sketch. Tatkal Podi survey number 46, certiorari, quashing the order, and consequently remand back the matter for first disposal in accordance with law, with suitable directions.
ಆದೇಶದಲ್ಲೇ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಯಾವ ಕಾರಣಕ್ಕೆ ಅಂತ.
ಅಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಇದೆ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂದ್ರೆ even this excess they can't do it.
See how many years have elapsed. All these days, how so much developments have happened. You have kept quiet for all these days. Now, all of a sudden, ಈ ಪೋಡಿ ಮಾಡಿ ನನ್ನ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಕಮ್ಮಿ ಇದೆ ಅಂತಂದ್ರೆ ಅದು ಇಟ್ಸ್ ನಾಟ್ ಕರೆಕ್ಟ್.
46 ಅಲ್ಲಿ ಹಂಗೆ ಇರ್ಬೇಕಾ? ಪೋಡಿ ಆಗ್ಬೇಕು. If they're in excess, I will recover from them by filing civil court. If I am in excess, they can recover. Partition deed is not challenged. RTC extracts will not, they are not.
You have to challenge. I need not challenge.
ಆಯ್ತು.
It requires detailed examination.
Let it go before appropriate bench, sir.
Please.
Please.
Having heard so much.
If you want, I'll refer it to mediation.
Well, mediation doesn't happen because, well, her husband is dead. They want to, my lord, still want to harass her.
That is
And they were not even
See,
ready
not
to.
correct. I am sorry.
ಕೋಡಿ ದುರಸ್ತಿ ಎಲ್ಲ ಆಗತ್ತೆ ಗೊತ್ತಾ? ಒಂದು, there should not be dispute with regard to the extent of property concern.
True, my lord.
Say, listen, Podi Durasti, when we can order, when there is no dispute with regard to extent of the property concern. Okay. So identification of that particular piece of property. Now here, you people are basing your rights on a partition deed.
And RTC extract.
On partition deed, basically.
Please, lordships.
Basically under partition deed. So you will have to require that what happens? There is no there should not be any dispute with regard to that partition date. Number one.
Yes, lordship. Very true.
There should not be any dispute with regard to that partition deed. And then the Podi Durasti happens and identification of the land takes place. Okay, here two things are essential. One is there should not be any dispute. Second one is that amount of land should be available for partition also.
True, lordship.
These are the two aspects that needs to be satisfied over here. But now if anybody raises a dispute saying that, see, that partition deed is there, but the partition has not been acted upon as contended in the partition deed. As contended in the partition deed. And instead, by act of the parties, the partition deed stands modified. Because you have some amount of land in
51/1.
one particular survey number and an excess of land in another particular survey number. Then in that event, you will have to go to the civil court.
To that, my lord, only one question. My lord. It is not their case that partition deed is not acted upon. Kindly look at their objections filed. They accept the partition, they go before the authorities, revenue authorities, they take it.
If they accept the partition, yes.
They have
order can
accepted
be
the
passed.
partition, number one.
Lord,
My lord, 1 minute, 1 minute.
no, no,
Sir, 1 minute, sir, please,
ಆಯ್ತು ಮಾಡಿ.
please.
Torsi-
Only 1 minute.
Put in-
They have accepted the partition.
No,
If partition is accepted, I can pass it on.
no.
Take it turn to page 14, lordships.
Lord,
Sir, 1 ನಿಮಿಷ, sir.
ನಾನು ಮೊನ್ನೆನೆ ಹೇಳಿದೆ ತಮಗೆ.
What partition?
ಬೌಂಡ್ರಿ ಪ್ರಿವೇಲ್ಸ್ ಓವರ್ ದಿ ಎಕ್ಸ್ಟೆಂಟ್. ಬೌಂಡ್ರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವ್ರದೊಂದರಲ್ಲಿ ಇಟ್ಸ್ ನಾಟ್ ಲೆಫ್ಟ್. ಇಟ್ಸ್ ಅ ಮಿಸ್ಟೇಕ್.
Sir, 1 ನಿಮಿಷ, page
ಸರ್ವೆ
14
ನಂಬರ್
please.
51/1 ನಲ್ಲಿ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಟೆಂಟ್ ತೋರಿಸಬೇಕಾಗಿ ತೋರಿಸಿಲ್ಲ. ಬಟ್ ದೇ ಆರ್ ಇನ್ ಆಕ್ಯುಪೇಷನ್.
Sir.
ಹೌ ದಟ್ ಕ್ಯಾನ್ ಬಿ ರೆಮಿಡಿಡ್? No, my lord, we cannot accept that.
That's fine.
Sir,
Page
I'll hear
14.
him and I will hear you, sir.
Page, only this, page 14.
ಹಾ.
ಬಿ ಅರ್ಜಿದಾರರು ಎದುರುದಾರರ ಕುಟುಂಬದ ಸದಸ್ಯರು ಕುಟುಂಬದ ಆಸ್ತಿಗಳನ್ನು ದಿನಾಂಕ 14/1/82 ರಂದು ಪಂಚಾಯತಿ ವಿಭಾಗ ಪತ್ರದ ಮುಖಾಂತರ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದು. ದಟ್ಸ್ ದೇರ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ನಾಟ್ ಮೈನ್. ಸದರಿ ವಿಭಾಗ ಪತ್ರದ ಅನ್ವಯ ಲೇಟ್ ಹೊನ್ನಗಂಗಯ್ಯರವರ ಹೆಸರಿಗೆ MR ಸೋನ್ಸೋ ಮತ್ತು ಪಾಣಿ ದಾಖಲು ಮಾಡಿರುತ್ತಾರೆ. ದಿನಾಂಕ 82 ವಿಭಾಗ ಪತ್ರದಂತೆ ಹಾಗೂ ತದನಂತೆ ಜಾರಿಯಾದ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶ ಬರಗೂರು ಸೋನ್ಸೋ 48ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಆಗಿರುತ್ತದೆ. That's also theirs, my lord. And everywhere they've accepted that
Yes,
there is a
230.
partition.
230 will continue.
Lord, let it go before some other.
My lord, why? I don't know why.
It requires threadbare hearing because
My lord,
the
230
records
very
also
hard, please.
have to be seen. No, it's not. See, mediation ತಾವು ಕಳಿಸೋದಾದ್ರೆ I have no objection. Kindly send it to mediation.
He is not ready for.
Kindly send it for mediation. Let the parties resolve their disputes.
Not.
My lord, is he not ready to argue before this honorable court?
It's not.
Is that his contention, lordship?
Whatever. Yes, release from parted. Post it before appropriate bench. Call next week.
Next week, at least date, my lord.
Date kodat barala because it's going for. I said next week. Release from parted. Call next week.
Since
Post the matter.
urgency, my lord, that word may be.
Post the matter before appropriate.
one submission. Serial number 32. Senior ಬೆಳಗ್ಗೆ ಬಿದ್ದು ಸ್ವಲ್ಪ ಶೋಲ್ಡರ್ ಪೇನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. He will not be able to be.
I can't help it, sir.
Your Honor, he has been making submissions in the past. Let him make the submissions today. I have no difficulty.
Today morning, he.
No, no, when
went
it is
from his
convenient for them, he makes the submissions.
Went for a
Let
medical.
him argue the matter. There is no difficulty. He is a lawyer.
Sir, it cannot be decided today, sir.
No, no, it'll take 5 minutes.
See, the previous case,
This is a 20-year-old.
sir, the previous case, I had almost made up my mind. It was a small matter. But just because the senior counsel there expressed otherwise, I said not, I just said no. And
No,
the
no, I would
reason
only
is,
request 5 minutes.
no.
A
These,
submission of 5
these
minutes.
aspects, they are a bit delicate. We cannot tell it to you because it is not appropriate for us to hear it. That's all. Yes, release from parted. Call next week. Call next week. Post the matter before appropriate.
Your Honor, they have also not filed that document that you had requested.
Let
The
them do.
recorder has not been
It will
filed.
come. It will come up before the appropriate bench. So, yes.
Serial number 19, my lord.
Serial number 19.
Award copy file ಮಾಡೋದಕ್ಕೆ direction ಕೊಟ್ಟು I'm filing the award copy. The matter has become infructuous. because of-
Infructuous, sir. 1 second, sir. ತಗೊಳ್ಳಿ.
Yes, ma'am.
The advocate for the petitioner is absent. Huh? ಇದು ಕೊಡಿ. Red position copy ಕೊಡಿ. The advocate for the petitioner is absent. Huh? Next para. Disposal letter. The petitioner in the instrument petition has challenged the order passed on IA number 3 in CAA 48 of 2019 by so and so court via annexure F to the writ petition. Annexure F. ಎಷ್ಟು page number? The said application is filed under Order 6 Rule 17 to amend the application filed for interim prayers before the city civil court in an arbitration proceedings. Full stop.
Section 9 application.
The said application has been dismissed by the trial court, agreed by which the present writ petition is filed. Full stop. Next para. The learned counsel for respondent submits that the arbitration itself, the arbitration proceedings itself have been concluded between the parties concerned and an award has been passed. Full stop. Next para. In the light of the full stop, a copy of the award proceedings is produced before this court. Record. The same is taken on record. Full stop. Next para. In the light of the same, the writ petition is hereby dismissed as having become infructuous.
Serial number 18, my lord. It is adjourned. Interim order may kindly be continued.
18 ನಲ್ಲಿ interim order ಇದ್ರೆ extend ಮಾಡಿ.
Please, my lord.
Serial number 11. Sometime first
ನೀವು ಯಾರಿಗಪ್ಪ
respondent.
ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ ಅಜಿತ್?
ಅವ್ರು ಸರ್ ಅವರು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬಂದೆ ಫಸ್ಟ್ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಆಮೇಲೆ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬಂತು.
Have you informed him?
No.
Should
My lord, I
inform him.
appear for
Yes.
my lord, I appear for the petition on serial number 11, my lord.
Yeah, the respondent
If
wants
they're
to.
seeking for adjournment,
Yeah.
yes, my lord, interim order may be extended in that case,
The
my lord.
request of respondent call it 2 weeks interim order if any is extended till next date of hearing.
Please, my lord.
Anything else? ಅಷ್ಟೇ ಅಲ್ವಾ? ಯಾವ್ದು?
Serial number 5 is also password.
52730 ಅಲ್ಲ? ಆಯ್ತು.
Number 5. Sumana Naganan.
ನೋಡೋಕಾಯ್ತಾ?
Produce one judgment also. My contention is that even if this is a suit for actionable wrong, it has to be only under the Fatal Accidents Act because there is a specific statute for that. May I request your lordships to kindly take paragraph 5 of this?
No, see, division bench of our High Court is binding on me. But whereas High Court of Tripura, it's only a persuasive value. I cannot differ from it. See, you want time, I will grant you time. You want to look into some Supreme Court judgment, you come back, it's okay. Okay. See, otherwise, I'm bound by division bench judgment.
And in fact, the division bench judgment refers to the Supreme Court judgment also, my lord. In paragraph number
Okay.
19.
I'll say next week, on the next date of hearing, when I sit single, I will post this matter.
Yes.
So you come back, because this has to come before me on review petition. Huh? With the request of petitioner, call after 2 weeks. Call next week on the matter. Call next week. See, other issue may not hold much water. That is
the other issue.
joint and necessary party.
Their entire
Okay, you
claim-
make your submission. See, it's like this. It's not a vicarious liability. See, if they were claiming under him, then it is different. In the course of employment, if it comes about, then it is different. Okay, there is no question of vicarious liability over here.
The basis on which they claim that I was negligent is because the landowner had submitted a number of applications and I failed to consider it. That is their contention before the trial court.
That's okay. That's okay. That's a different thing altogether. That we'll consider. But this you address it.
Yes.
Because this is a moot point. See, but for this division bench judgment, probably what you said was valid. See, because one is common law action, but once it gets codified, it has to be under the statute. MEC, napa udarane, accidents. You cannot say you can have a separate cause of action under common law. Right. So
In fact, the preamble of this act itself says.
that's the reason I'm adjourning the matter. You look into it and come. But otherwise, division bench is binding on me. That's how it goes.
Yes.
New notice, Supreme Court judgment and
Please. I'll also.
Okay.
Please.
Assist the court in this particular fashion.
Please.
Yes.
27. 27.
Pleadings complete ಆಗಿದಲ್ಲ?
Argument ಆಗಿದೆ, we have given a synopsis also.
ನಂಗೆ ಮರ್ತೋಗಿದೆ actually ಇದು.
Argued nearly 3 days.
Sir, let it come before regular bench, sir. ನಂಗೆ ಮರ್ತೋಗಿದೆ, to be frank with you.
ಇಲ್ಲ ಇಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ತಾವ್ ಕೇಳಿದ್ರೆ
ಅಯ್ಯೋ, ಬೇಡ sir.
ಅಲ್ಲ,
Let it come before, I'm not inclined, sir.
Rashmi, kindly bear with me, because in this proceeding, only thing what we are achieving is, there is a fraud played by the case.
Sir, in your interest, better take it up before, let it come before another bench. Because if I remember, the mind of the court was something else altogether.
I have no objection to argue before your lord.
Yeah, I know.
Series of litigations.
Yes, release from parted. Call next week, post the matter before appropriate bench.
Interim order has to be extended.
Interim order, if any, is extended till next week.
Next week, your lord.
Yes, sir. Next week at the ಹೇಳಿದೀನಿ, sir.
30.
Yes, sir. Thank you.
Serial number 30. Nageshwar Rao.
Sanmati, ಏನಪ್ಪಾ, you want to file objections, ah?
Objections ಆಗ್ಬೇಕಾಗುತ್ತೆ, because your lordship, my kindly say, I have to take a strong ground that it has not been filed. I will take it, my lord.
because this matter will reach up to Supreme Court. Now, if I had not taken proper stand here, my lord, entire my pleadings will be dead.
Mr. Nageshwar Rao, he doesn't want to go on over here.
My lord, so that is very clear right from the day one. Kindly see, I have given him acknowledged copy of the
Yeah,
return.
yeah,
I have given
understand.
him a return
I'll
where he
call
has
it next week.
acknowledged.
I'll call it next week itself. I'll call it next
My
week
lords, my
itself.
prayer is this. As I said,
Understood.
let him my lord, I know I have nothing against Sanmati, I know him from the day one he comes to court. He will confirm that. The point is, if he has a point of law, let him place it on record without an opportunity to me. My lords may
He
decide.
wants to file additional objections. It seems. What can I do?
I have no problem. Kindly take it on record and close the matter. If
Well,
because of that it
kindly
goes against me, I am happy. I don't want to argue anything further.
When pleadings are not completed, it is not appropriate for the court to consider it parted. I wanted to pronounce judgment.
May I say this, my lord? May I say this?
Yes,
This
sir.
11-12 thing that I filed for 4 years and 11-12 they did, and that left me with a statutory remedy. Because of their inaction, nothing has happened in these 3 years. Therefore, I had to come to the writ court. Is my case from day one.
The only thing that needs to be looked into is whether the law proposed by the Supreme Court being
Your Lordship, if your Lordship give me just 10 minutes, my lord, I will demonstrate right now that Supreme Court facts are not applicable. Just 10 minutes, my lord.
okay,
Right now, my lord.
let it go before regular bench. Release from parted. Call
My
next week.
lords, may kindly request, I request this, kindly give him 1 more week. Kindly keep it with my lord, because 11 hearings have happened.
Your Lordship, right now I can demonstrate, my lord.
Let him demonstrate. Let him demonstrate and kindly decide. No problem. Kindly see, 11 hearings have happened.
Okay, I will say next week. Yes, sir. Release from parted bada. No release, sir.
Your Lordship,
Obliged to my lords. Obliged to my
I will
lords.
file it in the 1 week, my lord. Additional, but I will finish my submissions today, my lord.
You do one thing, you file it and make your submissions. I will call it next week.
Please.
I will call it next week.
Just 15 minutes ಆಗುತ್ತೆ ಅಷ್ಟೇ merits ಮೇಲೆ ಏನಿದೆ
I will call it next week. You file it so that you will also have a benefit of it and will.
Your Lordship, ಅಲ್ಲ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಜಸ್ಟ್ ಅದನ್ನ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಅವ್ರೇನ್ ಹೆಲ್ಪ್ ಆಗೋದಿಲ್ಲ ಅದನ್ನ ನಾನು ಹೇಳಿದ್ರು ಹೇಳ್ಬಿಡು. Your Lordship,
I can't follow Kannada, sir. Kindly say in English. I am sorry for that.
English.
Your
Submit
Lordship,
in English.
all submissions.
Language of High Court is English.
Your Lordship, legal submissions have already been placed on record. On that basis of legal submission, I will continue my
Yeah,
argument.
read the papers also. You do one thing. Whatever you want to file, you file it. I'll say next week. Next week I'll dictate orders.
Obliged to my lords. I am grateful.
Single.
I am grateful to my lords.
Then you want to clarify something, clarify also.
Please.
Okay, I will do it that way. The request of respondent, call next week.
Obliged to my lords. I am sorry for insisting this way, but my kindly understand
No
my
problem.
agony.
Your Lordship, this legal issue will have a bearing. It will not end here. That's the
I
problem.
have not raised any issue on merit, sir. You may be right. When High Court
file it, file
you
it.
succeed, you take the money.
Yes.
Obliged to my lord. Obliged to my lords.